Oh no, I see it's TAM 127.
Yes, sorry.
Sorry, I beg your pardon.
Sorry.
My fault. Yes. Yes, sorry, go on.
And so the approval is given, and we can see that at tab 128.
Yes.
Yeah, so it goes up to 800,000. Now this is a document attached to your witness statement. Having attended the meeting and having gained approval, you then went and you drafted this document, didn't you? For the joint managing directors to sign.
128?
Tab 128, yes.
Yeah, this was already there. If they approve it, they would sign immediately.
Yeah, and did you draft it?
Feroz.
Feroz drafted it. You say it was ready there. How could it have been ready there when the approval was given at the meeting? You wouldn't have known at the meeting whether or not you were going to.
Yes, if they approve it, they would sign. If they don't approve it, they don't sign.
Yes.
But the draft is ready.
The draft is, well, this is part of a larger document. If you look at the numbering at the bottom there, page
Yes.
41, clearly this is the 41st page of a larger document.
True.
What was?
There are other. This is the managing directors meeting. This is not specifically to discuss this issue.
Yeah.
There are lots of other issues because at the time, November 20th, the old managing director was released from his responsibilities, and there was a board in December appointing 2 managing directors, and both of them were not involved in the business, so they needed to get more familiar with the business and the issues, and we had so many things that were outstanding and needed decisions because the signature authority from the old managing director was put on hold.
So the whole document was drafted before the meeting, was it?
Yes, this is based on the board. This is the managing directors meeting, not the board meeting. Board meeting is in 2009.
I understand. And do you take responsibility for drafting the whole document?
Drafting
The
is
content.
Feroz, but reviewing the content is me, yes.
So that you take responsibility for the contents of it?
Yeah.
So is it fair to say if any document like this, title like this, you would take responsibility for the drafting of it?
Yes, this is, these are decisions, most of them.
Decisions?
Yeah.
Okay, let me ask you about the document at D3156. Sorry, I beg your pardon, it's a wrong reference. D3, no it's not, 156, sorry it is 156.
156.
It's a similar style of document. It's,
Long-term incentive.
yes, long-term incentive for the signature and approval of Mr. Al-Daboos. Again, would you take responsibility for the contents of this document?
Yes, definitely, I would be present in that meeting.
Yeah. And if I can ask you about another similar document, D4228.
Yes. Yeah, I see it.
Yeah, the same sort of document, similar
Yes.
layout, seeking approval of Mr. Al-Daboos seeking a signature. Would you take responsibility for that document?
Yes.
So although it may have been typed by somebody else, the words there that we see are yours?
DAE management recommends.
Yeah.
So I am DAE management, part of the management team.
And so, again, the responsibility of the accuracy of the contents of those documents lay with you.
Yes.
So once approval for the extra amount had been received, Sorry, bear with me. If I can go back to 30 questions that you were being asked before about the rating. Can I ask you to turn to tab 130? Yeah. No,
Performance review form.
yes, this is a performance review form for year ending 2009. When you came to give your rating 3.9, is this the sort of document that you would have had before you?
No.
So, in relation to the approval, the board's approval for the increase from 600,000 to 800,000 dirhams.
The managing director's approval.
Sorry, the managing director's approval.
Yeah.
I beg your pardon, Mr. Shadwell. Managing director's approval. The claimant, or rather that payment to the claimant was late, wasn't it?
I remember, so it was delayed, yeah.
It was delayed. And the claimant kept asking you about this payment, didn't he? And he kept telling you, look, it's late.
No, when I knew that it was late, I took action, I remember.
Well, can I ask you to turn...
Because the approval was very clear to release the payment.
Pardon?
The approval, as far as I remembered, was very clear to increase the amount and release the payment.
Okay. Can I ask you to turn to page 618, please?
Tab
135.
Yes.
It's an email dated the 29th of March from the claimant to you. Subject to outstanding bonuses. Payment to client bonuses remains outstanding for a significantly long period now. I've discussed this matter with you on a number of occasions and was assured that payment was imminent. I have yet to receive the due amounts. Could you kindly advise? Now, in the claimant's usual polite fashion, he's saying to you, isn't he, that these payments are late. Can you do something about them?
Yes.
And he has therefore had a number of discussions with you, hasn't he, about the late payment?
But again, if you see the same time, the same day, I forwarded the email to Feroz, what is holding the payment? Because the MD approval is there from January.
Yeah. And what he's telling you, isn't he, he's saying to you, look, you're in breach of my agreement, can you please make these payments? They're late.
No, never did that.
There's a two-stage exercise, presumably, therefore. First of all, there's the approval exercise, which has been gone through in this case. And then there's the sort of administrative exercise,
True.
which involves the, what one might call the treasury area of the company, responding to the approval information. And sometimes between the approval and the response, there falls a shadow,
Yeah.
or at least a delay.
And this is, yeah, it was more of a procedural point that got stuck.
Yeah.
But not the company. The company was very clear, the approval and pushing forward.
Yeah. Well, the approval came on the 5th of January, didn't it?
Yes, from the managing directors.
Yeah. And the payment was made in April, wasn't it?
And definitely after March 29.
Yeah.
Yeah.
And so that's a 4 months delay. It's a significantly late payment, isn't it? Even by bureaucratic standards,
Yeah.
admin standards.
Again, I was, again, from the same time I knew about it, I contacted Feroz. I don't know exactly when the payment was made, but I believe it was in April payroll. But it was never presented as a breach or a delay, like delay in payment.
So you accept,
That's it.
you
It's
accept
delayed payment.
It was a delay. You accept it was a delay in payment.
It's a delay, very clear, from January till March.
To put not too fine a point on it, at this time, when, which we're concerned with here on these dates, between January or February and through to April, the company was in a tight cash flow situation.
Yes, but definitely it wasn't the reason why this wasn't paid.
You said yesterday that you couldn't remember the claimant giving you his IPC on or about the 24th of January 2009. It's right, isn't it, that at the beginning of 2010 he also gave you an IPC, didn't he?
I'm sorry, I don't remember.
You don't remember. So you could have done, but you simply just don't remember. And I also asked you about HR practice in terms of dating these IPCs, and you said that you didn't know what HR practice or protocol was. So if I suggested to you that when an IPC is reprinted, it's signed for a second time, and when it's signed for a second time, the date features at the bottom, which is the date of signature. Is that something that you could assist us with, or is that something that you don't know?
I'm sorry, no.
Can I ask you to turn at D2, please?
Yes.
Just wondering if you can help us with something in relation, another issue in relation to these IPC forms.
Tab.
Yes, if you just bear with me a second, please. Can I ask you to look at tab 83, please? And page 444.
Yes.
Now, I understand that this was before your time, but these IPCs were sent to you in August, and the email that I've taken you to on a number of occasions, and this IPC was part of that. The reason why I've taken you to this one is because it shows the name of the individual whose IPC it is, and that's Rob Janice's. Can you see that?
Bob Janice, yeah.
Yeah, 18th of June 2008.
Mm-hmm.
Can I ask you then to turn to tab 95, please?
Yes.
Going to suggest to you that this is also Robert Janice's form, and the reason why is because it clearly states function DAE Capital, and the only person from DAE Capital that was reporting, or would have been reporting to Bob Johnson is Mr. Janice. That's right, isn't it?
Yeah, I believe so. Yeah. I cannot see the name, so I cannot confirm, but,
No, but
it looks
no,
like it.
But you've told us that the CEO of Capital was Bob Janice.
Yes.
He had people reporting to him, but he in turn would report to the CEO.
True.
So this IPC can only belong to Rob Janice.
I think so.
Yeah. Now that's dated year 2008 at the top. At the bottom it's 17th of September 2008. Mr. Bob Johnson wasn't imposed at that point in time, was he?
Wasn't?
Wasn't imposed?
No. In September.
Can you maybe assist us, or if you can't, then that's fine to say I can't, but can you tell us why then that would say Bob Johnson, manager's name, with the date of 17th of September at the bottom?
I'm sorry, I don't know.
No.
Well, you were in place then?
Yes.
Just. With a very full desk load.
At the time, Bob Johnson left already.
Yes.
Yeah.
You had a very full desk load.
Yeah.
And if we, sorry, just keep a finger at page 500 and go back to the one at 444.
Yes.
If we look at the key performance indicators, can you see they're very different from each other, aren't they?
Comparing 444 with 500?
Yes. If you look at what's in the boxes,
Mhm.
in the key performance indicator column,
The individual performance contract or the individual performance contract?
yes. We're looking at two IPCs for year 2008. I'm suggesting to you that they are different, even though they cover the same period.
They're different, yeah, I
Yeah,
think
but
so.
You wouldn't say, would you, that Rob Jennings concocted either one of these IPCs, would you?
I can't tell. I'm sorry.
No. And then if we look at the one behind tab 98,
98. Yes.
so
The minutes?
page 503, tab 98, D2.
I'm sorry. 503, yes.
Yeah. So this is another version of an IPC for the year 2008, and using the same analysis as before, it's a DAE capital employee, reports to the CEO, George Bashafar, which is you. This must be Robert Janice's IPC, mustn't it?
DA capital, yeah.
Yes. And so again, this is a different version of an IPC for Robert Janice for the year ending year starting 2008.
But these were never, I don't think these were the IPCs. There's no signature here. I don't know. Again,
But you wouldn't say, would you, that Robert Janice has concocted any of these IPCs?
no, maybe different version, but not the final version or the approved versions.
Well, the KPIs have been changed. There's no doubt about that. At least these documents give the appearance of a change in the KPIs. Is that anything you know anything about? The change, the reason for it, or who did it?
No, definitely not me. But I'm sorry, I cannot remember exactly.
No.
Yeah, but definitely not me.
I mean, they are completely different.
Mm.
It looks as though somebody who's has looked at the original KPIs, regarded them as really quite unsatisfactory, and rewritten them. If you look at,
Yeah.
for example, customers, the format of the IPC, of the form, appears to be different. Because if you see, there's no, in the 500 one, the one at page 500, that's the one dated the 17th of September, there's a heading, processes, whereas in the other one finds customs. It rather looks as though the format of the IPC has been altered between the two dates. Were you party to anything about that, or know
No.
anything about it at all?
No.
No.
The first one, Bob Janice. The second one, Bob Janice. And the third one, my name is on it, but the 500 and 503 are the same format, but different amounts, lesser amounts in the financials. Maybe different drafts.
Rather looks as though the methodology in play in the year 2008 was somewhat fluctuating.
It was, as I believed or as I knew that time, it was a changing environment for everybody. Even even when Mustafa joined the DAE, the effort was different, or the emphasis was different. And then, unfortunately, the financial crisis came in.
You said you placed that, I think, in the autumn of 2008,
Yeah.
the financial crisis.
Yeah. So Mustafa, I believe, joined sometime end of 2007. The CEO was changed in June 2008.
Yeah.
So these were two major changes and major shift in direction. And then the financial crisis came in September. So before the crisis, there was a change in the approach of DAE. And after the crisis, definitely it was totally a different beast.
Would the, I mean, you said in answer to my questions that you don't know how it came about that these changes took place. And so any answer you give to what I'm now going to ask you has to be to some extent speculative. But would the HR committee at this stage, in this sort of intervening period, have had any input on this?
Again, as far as I know, yes, they had like a very important role to play in changing the landscape of the contracts and the employment structure of the organization before I joined and before the financial crisis.
Really? Yeah. And so might the situation have arisen where the IPC format and indeed the targets for an individual were changed by the committee, maybe without reference to a new CEO, i.e. Mr. Mushawa?
Yeah, maybe.
Yeah. So maybe Mr. Ramadan will be able to throw light on.
He was the head of the NRC.
Yes, quite so.
Yeah.
Okay, thank you.
Thanks.
And then in June, around about June 2010, the governance
Any document?
structure changes. Well, if you
Overall.
you tell me you don't know the helpful document, of course, Mr. Chairman, I'll take you to it. But I don't think it's controversial. June 2010, there's a change in governance. 3 committees get reduced down to 2.
Yes.
Yeah?
They're
So the
not
original investment audit HR committee are reduced down to audit and executive committee.
True.
Yeah? And the members of this committee are Dr. Al-Zaruni, Mr. Al-Dabous, and you.
Yes.
And in actual fact, this executive committee only has 1 meeting. That's on the 23rd of June.
Yes. My birthday.
Pardon?
My birthday.
Your birthday?
Yes.
Well, I hope you had a nice birthday. And you attend this meeting on the 23rd of June, and there are minutes of that meeting, and I took you to it yesterday. Page 647, tab 142.
Yes.
Yeah? And it talks about you negotiating with the capital team and so forth. It was said in that meeting 2 phrases. You say pay the employees wish the bonus to be paid as per the contract. You tell them to do that. And then later on in that paragraph, Mr. Al-Dabous says, well, after extensive deliberations, as the bonus is contractual and due to the critical stage of DAE, Capital Committee accepted the proposal. Now, you don't use words there such as discretionary bonus, ex gratia payment, gratuitous payment, do you?
No, I don't think so. I remember that meeting. It was discussed the bonuses and the item.
And say contractual? Just in sort of bullet points, what do you mean?
Contractual, that the employees are eligible for these bonuses as per their contracts.
And when you say eligibility is, there is a term in the contract that provides for a bonus to be paid to an employee.
Not referring to the contract, yes, definitely eligible is they're eligible for bonuses, and this was 2010, so definitely we passed the
So,
second year of supposedly contractual bonuses.
so it's a two-stage process, isn't it? It's one, whether or not the contract provides for it, and two, the conditions that an employee may have to meet to be able to get a bonus.
In general, yes, yeah.
Now, around about this time, so not around about this time, moving forward October,
October 10?
yeah, in early October, you thought, didn't you, that the HR function, that's everybody in the HR department, including the claimant, was redundant.
No.
You didn't?
No, at the time, because there were lots of changes in the company, and if we wanted to downsize that function, what would be the case? But I didn't say that they are redundant.
Okay,
No organization can have.
let's turn to your witness statement, shall we?
Yeah, sure.
Paragraph 77. By early October 2010, the DAG Group had been significantly slimmed down, and long-standing recruitment fees and downsizing operations were by then substantially complete. However, there were ongoing requirements to cut costs and administrative and support functions. HR had a disproportionately high headcount given that the group's business operations were much reduced. Although the senior HR function was obviously redundant, I was aware that it was not desirable to terminate Christopher's employment on the basis that it would have been an expensive exercise and his contract was due to expire the following year in any event.
So not the department.
The HR function,
Senior HR function.
but the senior HR function was the claimant, wasn't it?
Yeah, that's right. Although the senior HR function was obviously redundant,
Yes.
I was aware that it was not desirable to terminate Mustafa.
Yes.
So the senior HR is Mustafa's
Yeah.
employment on the basis that it would have been an expensive exercise and his contract was due to expire the
Fine,
next year.
Mr. Chairman. Let me take it in stages. So, firstly, you did think the senior HR function, that's the claimant, his role, position was redundant.
Because of the downsizing of the
Yes.
functions of the company, yes.
Yeah. So in effect, DAE didn't necessarily need a senior HR person.
On a full-time basis.
Yeah. However, you then go on to say, it wasn't desirable to terminate Mustafa's employment because it would have been an expensive exercise. Yeah?
Yes.
Now, the only way you would have known in early October 2010, when you decided that the HR function was redundant, that it would have been an expensive exercise to terminate Mustafa's employment, is if you would have looked at the contract and seen and considered and evaluated why it would have been an expensive exercise.
No.
How did you know that? It would be an
Again, at the
expensive
time, I remember, I don't know if this was before this date or after this date, I had a discussion with Mustafa on downsizing the HR function, and I believe he sent me an email, what would be the cost for downsizing the department's employees.
Yeah, and he provided you with his own cost of downsizing.
As far as I remember, I'm not sure, but as far as I remember.
And So let me take this in stages. You have a conversation about downsizing, Mr. Mushammar.
Yes.
You have a conversation about downsizing.
We always used to speak freely. And,
Yes, speak freely.
yeah.
And you ask him for a cost impact calculation. So what the impact of terminating the senior HR people, the HR people's employment, Mr. Mushammar?
Yeah, like the downsize, what would be the cost implications and what would be the cost to pay.
And you ask him for a cost impact calculation, and you ask him to provide one for himself as well.
I don't remember if I asked him, but I remember he did provide.
Yeah, and from that cost impact calculation, you understood that it would have been a costly exercise to terminate his employment.
Mm-hmm. Yeah.
Is that what happened?
Exactly, yeah.
Yeah. So he provided his own cost impact calculation. There's no reason for him to provide that unless you would have asked him, is there?
Mustafa sometimes does that without asking him.
Right. But in the context of saying to him, as part of the discussion, we don't really need a HR function anymore. Let's look at how we can downsize and reduce the headcount. In that context, it would be perfectly reasonable and appropriate, in fact, for the claimant to provide a cost impact calculation, wouldn't it?
Definitely, I asked him, well, we need to downsize. And I asked him for the other cost of the people, the impact of the cost. But I don't remember asking him to provide one for himself.
You don't remember?
No.
But it's reasonable that he would have done in the context of the conversation that you had.
Maybe, yeah. Because he did it in the response to the query.
Well, let's actually look at paragraph 77, because the way that's set out is you first talk about the expense of terminating the claimant's employment, and it's only after you say it would be expensive that you then say that you asked him to prepare a cost impact analysis.
Yeah.
So before preparing the cost impact analysis, you would have considered the cost of the claimant's employment being terminated.
Not specific, definitely, because again, I assumed at the time that all contracts are the same, and we had lots of people terminating their employment before that. Mustafa handled them, like Mark Calver or I don't know, not the treasurer. I can't remember his name. So if they had similar contracts, it would have been expensive.
Okay. Well, accepting what you say, the fact that you had a discussion about reducing costs, termination, HR function being redundant.
Not the function. Not the HR function. We had to have an HR function
Well,
in the
that's what
company.
you say.
Senior HR function.
I beg your pardon. It's not completely unsolicited then, is it, that he sent you this cost impact calculation?
His calculation or the people or the department?
The whole cost impact calculation is at tab 147. He sent it to you October 11th, 2010. The calculation is at 663.
Yes, I see that.
Yeah. So in the context of you telling him, you need to reduce headcount, senior HR function is obviously redundant. It's not completely unsolicited, is it, that he sent you this cost impact calculation?
Not necessarily I told him that the senior HR function is redundant, but I asked him for ideas to downsize the department,
Yeah.
because of the reduced tasks.
Yeah. And you don't respond back to this email, do you, saying, why have you sent me your cost impact? I didn't ask you to. Do you?
Yeah. But definitely I discussed it with him.
Yeah. You discussed the cost of terminating these individuals' employment, including the claimant.
Maybe not him, but definitely the others. And after that there were some people who were let go. Not him.
And it wasn't obvious to you, was it, that he wanted to be paid off by the defendant at this point?
He wanted to pay, I'm sorry, again.
Is that, those your words that he would want, it was obvious to you that he wanted to be paid off, Mustafa wanted to be paid off? Is that terminology you use?
And, I don't know what was the purpose of giving that, but definitely it's a huge amount.
Yeah, but it wasn't obvious to you, was it, Mr. Shahwar, that he wanted to be paid off?
No, I don't think so. No. It was leading to it maybe, but not specific or implicit or explicit.
Yeah, and so this part in your witness statement, 77, whoever's written it for you has got it wrong, hasn't it? It was becoming increasingly obvious to me that Mustafa wanted to be paid off and released from DAE.
Maybe it was not, but again, this is my statement. But maybe it was not as obvious, but definitely it was discussed, and definitely I'm more certain that it was presented to him after discussion how to downsize the department itself.
And again, when I put that question to you,
Yes.
it wasn't obvious to you what it meant about being paid off. That's not terminology that you would use anyway, is it?
Maybe I'll use different things.
But in fact, what was happening at this time in the company was that financial burdens, or it was the crisis was going on, it was reducing costs, downsizing, terminating people's employment, and so the defendant, I'm going to suggest to you, wanted really to terminate the claimant's employment because that senior HR function was redundant. It had no need for a senior HR person, did it?
No, we didn't. We didn't need a senior HR function to handle the tasks at the time.
Yeah.
But we didn't want to terminate the defendant. No.
And somehow or other, the defendant was looking to see ways in which it could terminate the claimant's employment without having to bear the costs of any termination.
No.
Sorry, just a minute. Mr. Al-Hindi was, in your eyes, as I understand it, quite an expert in the HR field.
True.
And the level of the number of employees which the company had, of course, had dropped as you got towards the end of 2008. And as I understand your evidence, and correct me if I'm wrong, inasmuch as it had dropped to the point where the kind of expertise which he had to offer wasn't an essential requirement of the company any longer. Would that be an
Yes.
accurate
Yeah.
put it?
Because,
In other words, it had an expensive facility which it couldn't really, or was really unnecessary for the purpose of running the company.
yes.
Yeah, I think. Was the, so far as you remember, was the cash flow situation, which is obviously severe, getting worse as 2008 came to an end?
2008 or 10?
Sorry, 2010.
10. We were in a better position than 2008. And,
Really?
yeah.
Yeah.
And at paragraph 78 of your witness statement, you say that around about this time, Khalifa Al-Daboos became aware of the cash payments being made to Mustafa in lieu of actual reimbursements for allowances. How did Mr. Al-Daboos become aware of this?
Definitely I must have told him because I had constant meetings with Khalifa.
And you say there was an increased focus upon corporate governance within DAE, including ensuring a robust audit process. That increased focus upon corporate governance, ensuring a robust audit process, that responsibility fell on your shoulders, didn't it?
The audit, yes. The governance model.
Payments and governance, and you were responsible for it, you would have been held accountable for it.
As a CEO, yeah.
As a CEO. So, you tell Mr. Alderbus about these cash payments being made in lieu of allowances. How do you come to be aware of that?
Maybe discussions with Narissa. To be frank, I don't know exactly, but it is around this time. So maybe discussions with Narissa, maybe discussions with Mustafa himself.
Well,
I don't know exactly.
Yesterday you said that the reason why you became aware is because you looked at his contract of employment.
After I knew, I checked the contract.
No, you said yesterday, we can check the transcript, around November of 2010, when this allowance issue was being raised, you looked at his contract of employment.
Exactly. When I knew of this fact, I checked the contract, yeah.
So, you go and you look at his contract, you take the contract out. wherever it is.
I remember I asked Narissa to send me a copy or an extract.
Okay. You get sent a copy. I mean, you wouldn't necessarily ask for an extract, would you? Because you don't know what you're looking for. You don't know which clause you're looking for. You don't know where it is, what the number is.
Specifically the allowance.
Yeah. But
Narissa would know.
okay. But it's more than likely, is it not, that in view of this robust audit process and the increased focus on corporate governance, that you asked for the entirety of the contract, didn't you?
Yeah, most probably.
And in view of this increased focus on corporate governance and the robust audit process, you would have looked through the contract.
Mustafa's contract.
Yes.
Yeah, at that time, yeah.
Yeah. And therefore you read the contract in its entirety.
Not necessarily. Specifically for the allowances, definitely I read it.
Is it a case that you can't remember whether or not you read all of it?
Yeah.
But let's go back in time, November 2010. What's going on around us is that there's a robust audit process, increased corporate governance, people are asking questions, companies in crisis mode. Your responsibility to the board as a CEO, acting CEO, it's more than likely, is it not, that you would have read the contract to see what the provisions were there.
True.
And you would have also chanced upon this bonus entitlement provision.
Definitely I would have, yeah.
Yeah, because anything to do with payments going out to the company is open to criticism or questions, should I say, open to questions and clarification.
But at the time, the issue mainly was the allowances and the cash in lieu of actual expenses.
Yeah, but again, in your mind at this stage, you know that bonuses are being paid, and you've looked at the contract and you've read the contract, but yet you've got no objection, and you say nothing about these bonuses that are being paid.
No.
Because there was nothing wrong with the bonuses being paid.
Again, the focus was the allowances at the time.
Would that be convenient, ma'am, to have a short break?
Yes, I
You've been getting quite a long time.
All right. I think I might finish, you know. About an hour and a half.
subject to, so.
Did you say it was very close yesterday? I can't remember. Did you say it was going to be What's your
Yeah, he said that you get things actually started on 9:30 beforehand.
Yes.
Needs to go through. Control and type something.
That's right. Okay, so it's your dog marks.
Do you mean like check marks or anything?
Yes, it's really distracting because it's all orange and it's not.
Sorry.
Is it your equipment or theirs that's causing that sort of feedback?
We're not amplifying anything.
No.
This is amplified. So I think
Well, I wonder
sometimes
whether
it's
we
where
might-
some of the microphones are sort of near each other, but I don't know how many there are.
Maybe if we put ushers there away.
Because ours are not.
Yeah, well, we've done the same, and we'll put that there because that's just painful.
Is that colour?
It's not the background that we want, it's the foreground, so I'm going to change the...
So the orange, the
yeah,
orange background.
yes, it is.
Okay.
It's untranslates, and then I'm going to do foreground, not blue, but I'm going to make it like... No, not orange, because my one is orange, yeah. So like, I don't know, purple?
Try that one. Yes.
You happy with that?
That's fine as long as that's dark enough for you to see.
That's fine. I think that's what your original colour
That's
was.
what it was. So
It's just that when you do, because it's the point, the problem is that it's so distracting and it's that big block of colour. It has to be like, it just has to be the colour of the actual word, not like that. You know what I mean?
And did you want to change that?
Yes,
So is
that was the one
Yeah,
that I
so
was
what
saying.
do you mean on to brighter?
Yeah.
But more different to.
Yeah, yeah. So not orange, but because obviously orange is my favourite colour as a one. What do you think? Yeah. So maybe, yeah.
Oh, because my arm translates to.
Okay, with that bright green and what yes, no, that's the
I just want to be dark enough for your room.
yeah, let's do that.
Let's see. No, that's close. Do you think? Or is that
That's
better?
okay.
Is that
That is better. I mean, we can change it later, but I'm happy with that.
Let me know what is better.
Yeah, that's fine. I'm going to
I'll try.
Two, yeah. Emirates Towers. Yeah, yeah, yeah.
Yes. It's an important.
Postponed several times.
Pardon?
Postponed several times, that's why.
Huh? Yeah, I'll just get one system. Thanks, you again. But then what do you think? Next time, I'll get them on. Thank you. All right.
Yeah.
Michelle, can I ask you to turn to D3148, please? Tab 148.
Yes.
So this is an email that you write on the 24th of November. And you say, please ensure that no employee receives his contractual allowances in cash on a monthly basis unless the contract explicitly stipulates that. Allowances that are capped should be supported by actual cost income and should not exceed the contractual cap. Any special approvals or exceptions should be supported by approval from the Managing Director. Two things. Firstly, when you say please ensure that no employee receives his contractual allowances, you're talking about the claimant specifically, aren't you? Because there is no other employee.
Receiving it in cash, no.
Yeah. So why do you not simply say to him, Mustafa, please ensure that you don't receive any contractual allowances in cash on a monthly basis?
Because it's a matter of policy, company policy. It's not specific. It happened that Mustafa is the one at the time.
Allowances that are capped should be supported by actual costs incurred and should not exceed the contractual cap. Now, the contractual cap was $150,000 per year. Isn't it?
As far as I remember, yeah.
Yeah. And the claimant wasn't at any point exceeding that cap, was he?
The claim? I'm sorry, what was
Sorry,
it?
I beg your pardon. When he was receiving these cash allowances in lieu of his benefits, 12-month equal
12 and a
payment,
half.
yes, he wasn't exceeding that $150,000 per year cap, was he?
Yes.
Yes, you agree with me, or?
Yes, he did. But again, it's the contract at the time. It was stipulated that it is on cash reimbursement, and Mustafa was the custodian of this allowance, in specific for all other employees. He made sure that they do not use more than what they should,
Yeah.
and they not exceed that amount.
Yeah. And this email is sent on the 24th of November at 1:30. And the following tab, 149, page 666, there's a subsequent email sent from you at about 4:30 in the afternoon of the same day. And you say, Mustafa, as per our discussion today, please revise the salary schedule to reflect the content of the email below. I'm aware that you have the approval of the previous CEO on the cash allowance payment, but as discussed, this will stop with effect from November's salaries. And any such approval has to be given by the Managing Director. Now, the claimant has a conversation with you, and he tells you, doesn't he, my contract has been amended as a result of the previous Managing Director,
Previous CEO.
CEO, approving, I beg your pardon, approving that amendment. That's what he tells you.
This is what he tells me. Yeah.
But you don't agree that that's an amendment to his contract, do you?
I'm not a legal or HR person. I had to check at that time.
You have to
And
check.
I wanted to get the approval from the managing director.
Yeah. And in checking what the legal position is in relation to this amendment, you ask your General Counsel, Ms. Jones, don't you? Ms. Jones.
Initially, I don't know when did I involve Leslie in this one, but initially I discussed with the managing director.
Yeah, but at some point you did involve Leslie, didn't you?
Yes.
And Leslie looked at the contract of employment for the claimant?
Should have, yeah. Definitely. I don't know if it should have.
Yeah, and Leslie gives you advice, doesn't she, that this is an amendment to the agreement.
I know that's not an acceptable question.
Why?
It's legal advice.
A big one.
It's legal advice.
Cross-examination.
Well,
You couldn't ask it, but she can.
Well, my lord, I've got a question there. Is she entitled to ask about legal advice that the company...
Oh, legal advice. I'm sorry. I thought you said it was a leading question.
No. Sorry. It's my learned friend's question was to confirm the legal advice that Mr. Mishrawa, on behalf of the company, receives from its counsel. That can't be permitted.
You can, of course, there are ways of getting around this.
Well, there are.
You're well aware as a cross-examiner.
My learned friend needs to find one.
Well,
Yes.
give me the opportunity. Can I ask you to turn to tab 173, please? Page 717. Now, you said that you're not a legal person, you're not a HR person, and that you spoke to Ms. Jones. You write an email on the 23rd of March to George Mushahwa. Please note that after considering the previous CEO approval, and since this constitutes an amendment to your contract, the managing director has approved the release of the allowance provision. Now, given you're not a legal person, that legal phraseology constituting an amendment to your contract didn't come from you, did it?
I would have consulted with
Yeah. And that came from Ms. Jones, didn't it?
I would have consulted with her, but maybe I wrote this. I don't know.
Yeah. And I'll tell you when you would have consulted with her. Can you go back to tab 172, please?
A, B,
I beg your pardon?
A, 172A.
Tab 172. No, 172.
Sorry.
No A.
Yes.
Yeah? Linda Brinkley, that's an admin person, isn't it?
My PA, yeah.
Your PA. To Leslie Jones, you're copied in. Hi Leslie, please see attached concerning Mustafa's allowances. I believe you're out of the office today but contactable, so please call George to discuss. So, you have a discussion with Ms. Jones. So she looks at the contract and she tells you this is an amendment to Mustafa's contract.
There we are again, my lord. That's asking for confirmation of content of legal advice.
Well, it's asking for confirmation of what's in the email
I'm sorry.
on page
It's not
717.
an acceptable question.
Page 717. It's following that discussion with Ms. Jones. Your understanding is that it constitutes an amendment to your contract, which is why you tell the claimant that on the 23rd of March.
That's my email of the 23rd of March.
Yes.
Yeah.
And so you accept what I'm putting to you.
This constitutes an amendment to your contract. Yes, this is what I wrote. And the allowances, I believe, were released in that month.
Can we go back to tab 152, please?
Yes.
Sorry, 152, page 671. Page 671, yep. Again, on the 25th of November, the claimant writes to you saying, reference the attached correspondence to be precise, the approval I received from the previous CEO is not on cash allowances payment, rather than a minor adjustment to two specific employment contract clauses. To this end, it's my belief that these changes constitute a binding addendum to the contract by mutual agreement. And what you're doing in your email of the 23rd of March is agreeing with the claimant, aren't you? This does constitute a binding addendum to contract by mutual agreement.
It was on the allowances issue, the amendment.
Yeah. And so you are agreeing with the claimant, aren't you, that it constitutes a binding addendum to the contract by mutual agreement?
Yes.
And the email above that, you say to the claimant, Mustafa, in order not to delay the salaries of November, please provide salary schedule without including the cash portion of the allowances in your salary. As discussed, we will clear this issue next week. And he says, we'll do, and you say, thanks. Now, this issue wasn't cleared up next week, was it? Because he wasn't paid his cash entitlement in lieu of those allowances in his November salary, nor was he paid that in his December salary, was he?
No. No.
And if we go to tab 150, page 668, this is the basis upon which the agreement was amended. If we look at this, and you read this email, didn't you? You
Yes.
had it? Yes. And looking at the second bullet point, housing and automobile allowances, my entitlement is for a company provided housing, car and driver, considering that I own a house and a car in, I propose encashing this annual allowance to be paid in arrears in 12 equal monthly instalments together with the monthly salary. So I'm proposing cashing this annual allowance to be paid in arrears in 12 equal monthly instalments together with the monthly salary. There's no question there, is there, about what the claimant is saying. He's saying, is he not, the annual allowance, which everyone knows is $150,000, is going to be paid that in 12 equal monthly instalments.
True.
And Mr. Johnson approves that, so it's 150,000, the cap, in 12 equal instalments.
Yes.
And by reference to the agreement, I won't take you to it. It's in accordance with the agreement, isn't it?
What is this?
To be paid 150,000 in 12 equal instalments.
Again, I wanted to check that because the agreement stipulated on cash basis, reimbursement on cash basis.
Yeah.
And this one was an email amendment, and that's why we wanted to confirm that this is legally binding first, or if we can find alternatives how to compensate Mustafa for his allowances.
And you found that it was legally binding
In March, yeah.
in March. And D3157 so we know the issue hasn't been cleared up in November or December. At the start of January then, on the 4th of January, he writes to you again, doesn't he? And the title is Monthly Remuneration. And the email starts, I note with concerns that for the past 2 months my monthly wages have not been paid in full and a significant portion of entitlement has been withheld without any official or proper explanation. So on reading this email, Mr. Mushahwar, you understand the words I note with concerns, that this is somebody who's not happy about the situation, is he?
He's not happy, yeah.
No.
But we always discuss this issue in specific.
Yeah.
There were continuous discussions on this issue.
And given in March you understood that this was a binding agreement, you'd accept, wouldn't you, that this cash portion in lieu of his benefits formed part of his wages?
It is part of the compensation or monthly salary.
And he's telling you there, isn't he, that this action constitutes a clear breach of the term of my employment contract. And that's what it was, wasn't it?
We were not clear at that point of
At
time.
that point. But when you do become clear in March, not paying him is a breach of the agreement, isn't it?
My learned friend keeps asking this witness a question which is just for your lordship. I don't know why he's been asked to deal with legal matters that are entirely within your lordship's
Well,
remit. It's an issue of trial.
I don't think his evidence can add anything to the legal analysis.
I'm grateful. I'll move on then. You then write back, saying you're aware of the, sorry, it's the email at the top, the second paragraph. You're aware of this and we discussed the issue a couple of times, and considering your actual cost of housing and cars expenses, you should be able to get reimbursement as per your contract. You're supposed to present these for approval in order to proceed forward, but it seems you elected otherwise. Now, the claimant says that yes, there was a discussion about maybe producing something in terms of the market value of cost. But he says that you never actually told him to go away and give you a valuation, to go and get one and give that to you. And that's right, isn't it?
No, I did ask him directly because I supported Mustafa at the time. That how can we justify these allowances and how can we resubmit to the managing director? And I told him go get even this was my idea to go get the valuation for the house and for the car.
But at the point of the 23rd of March, it becomes irrelevant whether or not he provides a valuation, doesn't it?
At that time, yeah, I managed to seek legal advice and confirm with the managing director.
Now, page 687, tab 159. He writes to you again on the 13th of January. And he says to you, it's still unclear to me what is the company's intended action to resolve this issue. Accordingly, for the avoidance of doubt and without prejudice, I seek a formal, individual and clear clarification to the following questions. Yeah? You then respond saying, I will address this issue once I return from my US trip, and that's on the 13th of January, isn't it?
This email is for 13th of January.
Yeah. And you return from your US trip on the 20th of January, don't you?
20th, yeah.
And
First working day was the 23rd, Sunday. 20th is a Thursday.
And the next thing is that the claimant, on the 30th of January, tenders his resignation. Now, your witness statement is silent on matters in between the 20th of January and the 30th of January. And so it's correct, isn't it? You didn't do anything about resolving this issue between that period.
Definitely we had constant discussions because, and again, the purpose of the US trip was to, and Mustafa was fully aware of the actions at the time, to negotiate with the capital team to waive the 50%. And Mustafa was one of them, so, or for the LTIP. And I constantly discussed with Mustafa before the trip and after the trip.
Yeah, but the waiving of 50%, we'll come to that. But I'm talking about the period between you returning from your US trip on the 20th and to the date that the claimant tenders his resignation.
5 working days, yeah.
There is nothing in your witness statement about any discussion, anything that you may or may not have done in relation to this issue. So, I mean,
yeah, maybe there is not, but definitely we discussed this matter.
I'm going to suggest to you that the reason why there isn't anything in your witness statement, because in fact, during that period, 20th of January to 30th of January, you did absolutely nothing about resolving this issue. And had you done, it would have been included in a very detailed, otherwise detailed witness statement.
I don't know, but definitely whether I was back, Mustafa was on leave, or but definitely because I used to go to the on a daily basis, and at that time I had constant meetings with Mustafa.
Now, you talked about waiver of the 50%.
Yes.
Yeah.
LTIP.
Because, yes, L2. Because around about this time, you were attempting to compromise LTIP bonuses for certain individuals, weren't you?
For all individuals with LTIP entitlements.
Yeah? So, let me take this in stages with you. Annual bonuses for 2007, 2008 and 2009 were paid to all eligible employees.
Should have, yeah.
As far as you're aware, they were paid.
Yes, this is 6 million.
And in terms of the annual bonus, I'm just dealing with the annual bonus here, in 2010, they were paid to all eligible employees apart from the claimant. That's right, isn't it?
2010, then it should have been paid in 11.
Yeah.
I don't know, I believe he was not paid. I don't know exactly, but I believe he was not, because usually it's next year.
Yeah. So let me put. Sorry, I beg your pardon. For the year 2009, he should have paid. He should have been paid in 2010, but he wasn't.
If you say so, I can't remember exactly, but if this is the case, yeah, fine.
In relation to LTIP, we know that that payment was made in two separate tranches.
The first 15%.
Yeah. So 7.5% of the 15% was the first tranche, and that was paid in July 2010.
Mm-hmm.
As to the second tranche, the 7.5, that was paid in January 2011.
6 months.
Yeah. The second instalment of LTIP, the 35%, was paid to all employees, wasn't it, except the claimant?
At the time, there was a waiver discussion. They waive 50% and then they get paid the 35%.
Yeah. And that waiver was in terms of D3, tab 165, page 699. Now, it was this kind of a letter, and this is a draft, I accept, but it was this sort of a letter that was sent to all those employees that were eligible for LTIP.
Yeah, I believe so. Yeah, this was
Yeah.
the basis of the discussion.
Yeah, so the 35% and the 50%. Yeah? And what they were being asked to do is that the company would pay the 2009 or rather 2010 annual bonus, sorry, the year ending 2010. So the 2010 annual bonus and a part of their LTIP, and in return the employees would waive their entitlement to the rest of the LTIP, so the 50% LTIP.
This was discussed with everybody, including Mustafa. Yeah.
And all employees, apart from the claimant, signed this sort of a waiver agreement, didn't they?
I believe so, yeah, but this was for everybody, including Mustafa. And always Mustafa said, you don't need to worry about me for this one.
So Mustafa said to you actually that he was not willing to sign
No.
such a waiver letter.
No, he always said, you don't need to worry about this thing for me. Just get the clearance from the US team and we'll proceed. Was my understanding.
Why would he say you don't need to worry about me?
Because he didn't believe that anybody would be entitled to LTIP, including himself. He always said it. With considering the company and the performance.
If you're offering to pay an amount and accept, compromising a bigger amount, but if you're paying an amount to employees that are eligible, and the claimant understood himself to be eligible, why would he say to you, don't worry about me?
I told you because this, again, considering when these contracts were signed and the state that we were in and the objectives or performance or the position of the company, the LTIP was not reasonable, let's say. That's why there was the 50% waiver.
Mr. Mushawa, he provides you with lists of those individuals that are entitled to this LTIP and what the proposed payment ought to be. Can I ask you to turn to D4 222, tab 222. 70.
Yes, I see that.
Yeah. This is a list for annual bonus for the period ending December 2010. So it must have been produced in the early part of 2011, yes? And it was the claimant who produced it, wasn't it?
I don't know.
And he
I believe
produced
so.
it. And he produced it after his resignation because it says on the right-hand side, resigned against his name.
It says resign, yeah.
Yeah. So if he thought that you should forget about him, and I'm paraphrasing here, then there'd be no reason whatsoever for him to put his name on a list like this.
This is not the LTIP.
The annual bonus.
Yeah, but he said that he will waive his right for the 50% of the LTIP.
Oh, the LTIP, so
Yeah,
not
like
the
a-
annual bonus.
No, because everybody waived the LTIP price. Not
Right, okay. Well, LTIP then, page 971. 35% LTIP. That was the LTIP in question, wasn't it? The second LTIP instalment.
35% second.
Yeah, and that's what it says at the top of this table. Again, one can assume that this table was produced in the early part of 2011 after his resignation.
Okay.
Yeah? So if he was under the impression that he didn't want it, then he wouldn't put his name on a list like this, would he?
Not necessarily.
Well, why not?
Yeah.
He's telling you that he's entitled to it.
He's telling that he's entitled to it and that he's resigned. And
Yes.
that it's my decision. But again, like everybody else, everybody was waiving it and everybody else's name is there.
Yeah.
So that doesn't mean that he will not waive it.
Yeah, but maybe we're talking about cross references. These are the individuals that are entitled to LTIP, the 35% LTIP. Yes?
Yes, I don't see the names, but yes, definitely. It's LTIP.
And the
third
claimant puts
LTIP.
his name on this list too.
Yes,
And against his name, it says resigned.
yes.
And so the claimant does think he's entitled to it, doesn't he?
He does think so,
Yeah.
like everybody else.
Like everybody else. But unlike everybody else, he doesn't sign the waiver letter, does he?
Yeah, I think so.
And the reason why he doesn't sign the waiver letter is because he, as is his right, wants the 35% LTIP.
The 35 or the 50%. The understanding was with everybody else that they waived the 50% to get paid the 35%.
Right. So he wanted his 50% LTIP. He didn't want to compromise his claims in relation to LTIP.
Clearly, and again, this is my discussion with Mustafa, that, and he clearly said, you don't have to worry about me, because I told him that in Dubai, there's only Feroz and yourself for this LTIP issue. And he said, you don't need to worry about me, just clear the US issue and then we'll discuss it.
Fact of the matter is that he hasn't even been paid the 35%, has he?
As far as I know, no.
No. Although, if all things stand correct and the court finds that he's contractually entitled to it, he should have been paid it.
The understanding was that the allowances would be reinstated, he would withdraw his resignation, and we proceed like everybody else.
And when you say proceed like everybody else, is that him signing a waiver letter?
Yes.
He always told you, did he not, that he would not sign a waiver letter?
No.
That's what he expressly told you.
No. Maybe after the result, but before it was clearly this issue of 50%. I remember because again I discussed all of these issues and the plans and the approach with the employees with Mustafa.
And paragraph 86 of your written statement.
My statement.
Yeah.
I have it in front of me.
Yeah. Actually, let me ask you this question. February you sent these waiver letters. The claimant says he's not signing a waiver letter.
I'm sorry?
February you send a waiver letter to the claimant, and the claimant tells you he's not signing that waiver letter.
I don't remember him telling me that.
There is then a discussion between you and the claimant, isn't there, whereby you invite him to retract his resignation, but you also say to him that he ought to waive his right to 50% of LTIP, retract his resignation, and in return you will pay the 35% LTIP and reinstate his allowances.
I didn't have to negotiate with Mustafa this because he always said that you need to worry about the US team. For me, you don't need to worry about it. We'll do whatever everybody does.
And he said to you, I'm not
So
prepared
I never did this. I never negotiated with him like the US team.
Well, and he said to you, I'm not prepared to agree to what you're saying. I want all my LTIP entitlement. I also want you to reinstate my allowances. And maybe then I'll retract my resignation.
No, I don't remember that, definitely. I clearly remember.
He did not agree, did he, to retract his resignation on the terms that you suggest?
Very clearly, again, this is my understanding of the various discussions that I had with him. That once we reinstate the allowances, he would continue, he would retract on his resignation, would continue, and we started even discussing a part-time basis for after October 11.
Okay. Paragraph 86.
Mm-hmm.
You say on the 23rd of March, on the basis of the matters agreed above, in paragraph 85.1, those matters that we've just discussed, I emailed Mustafa to confirm to him that the Managing Director had now approved the ongoing payment of the housing and power allowances, and these payments would continue. So, what you're saying in effect there, aren't you, that the claimant, rather there was an agreement between you and the claimant that he would retract his resignation, and as a result you would pay the allowances.
I would pay the allowances on the. This is the understanding was he would pay the allowances, he would retract his resignation and move on. Now, which happens first? There was an understanding on this one. Whether we pay, he retracts, or he retracts and pay. That's a different thing.
Yeah. So the only way that you're saying, well, what you said was that the only way that you would reinstate, and the only reason why you would reinstate the cash allowances, is if the claimant retracted his resignation.
No.
That's what you say there.
I'm telling him that on the basis of the matter that he was agreed the monthly cash allowances would be reinstated and that he would continue. But it was, at the time, it was not some sort of a conditioner that we'll pay the allowances, please withdraw your resignation. No.
No.
The essence of the discussions at the time that I had with Mustafa was that this resignation is something that he would retract easily, just reinstate the allowances and move on.
Okay, so let me get this straight. The basis of paying his allowances wasn't conditional upon the claimant retracting his resignation?
From day one, when the allowances stopped, I tried and I continued to discuss with Mustafa how can we reinstate these allowances
Yes.
from November,
Yeah.
and whether with the evaluation of the however, I never said that these will not be paid, so I cannot put them as a condition at the time. But it was portrayed as that we will we'll clear the allowances issue. Let's move on with the contract.
Okay, well, paragraph 85A, B and C, page 4, page 21 of your witness statement.
Yes.
What you say is this: it was my understanding that the following matters were agreed between Mustafa and myself regarding his ongoing employment with DAE. Yeah? A. It was agreed that monthly cash payment in lieu of allowances would be reinstated with retrospective payment for the months November and February, yeah? 2 February 2011, yeah? B. It was agreed that Mustafa would not resign as he had threatened and would continue to work for DAE at least until the end of the fixed term provided in his contract. C. Mustafa would consider working on a part-time consultancy basis beyond the expiry of the fixed term. Paragraph 86, on the 23rd of March 2011, and on the basis of the matters agreed above in paragraph 85, I emailed Mustafa to confirm to him that the managing director had now approved the ongoing payment in lieu of the housing and car allowances. Let's pause there a second. Can we go to your email of the 23rd of March, please? D3 tab 173.
Yes.
What you say in that email that comes after the discussion, the version of the discussion that you say in 85, paragraph 85 of your statement, you say, please note that after considering the previous CEO approval and since this constitutes an amendment to your contract, the managing director has approved the release of the allowances provision, US dollar $150,000 to you, which will be payable on monthly equal instalments retroactive from November 2010. Please coordinate with payroll to action the above. You don't say there, do you, that the basis upon which we are reinstating your allowances is because of all those matters agreed earlier, namely, we'll pay you a monthly cash payment, you won't resign, and you might consider working on a part-time basis. You don't say that, do you? No. And the reason why you don't say that is because none of those matters had in fact been agreed.
No, they were.
And
My
had they...
understanding was very clear, and again, you can refer to the statement. It says, even the first one for the allowances, as I had intimated to Mustafa from the outset of my discussions with him, from the beginning, it was clear that these allowances would be reinstated, but how to do it, how to support it, was the issue that me and Mustafa were always discussing. And even in B, would not resign as he threatened and would continue. So I consider the resignation more of a threat and nothing else, not serious.
Yeah, but if that was what had been discussed, Mr. Shamrock, you wouldn't have said in this email that the only reason why we're paying you is because it constitutes an amendment to your contract. You would have said, we are going to reinstate it, and on that basis, you're going to retract your resignation.
No, not
and
necessarily.
we're going to consider you working on a part-time
Not
basis.
necessarily at all. I am clear of that in my mind.
Right. So in relation to this agreement that was reached prior to this email on the 23rd of March, the claimant says to you, in terms, that, actually let me put this question, in terms of this agreement about working on a part-time consultancy basis, you told the court that the senior HR function had been reduced.
Yes.
It's also right, isn't it, that the claimant told you about the possibility of another job in Abu Dhabi.
He mentioned that, yes.
And so, by reference to those two facts, it's not plausible, is it, that there is some agreement to consider working on a part-time consultancy basis?
We discussed it, and it was a part-time basis. And again, because of the reduced efforts and tasks at DAE, but we still needed HR, and we still needed Mustafa's expertise, because he's the one who knows all of these contracts. So that's why it was a part-time basis. So maybe 1 hour a week, or maybe 10 hours a week.
And
But the discussion was held.
But during this discussion, Mr. Al-Hendi told you in terms, didn't he, that I resigned because you unilaterally revoked part of my wages. He told you that, didn't he?
He
You're nodding
said-
your head.
I'm sorry, no.
Is that a yes? Or-
Yeah, I resigned because
Yeah. You, on your own back, unilaterally took the decision not to pay me part of my wages.
for the allowances, yeah.
Yeah. He also said to you that the only basis upon which I will consider your invitation to withdraw my resignation is if you confirm to me in writing that you will pay me my LTIP instalments of 35% and 50%.
No. I cannot remember that at all.
And that conversation arose because you invited him to sign the waiver letter.
Again, I do not remember at all him putting this as a condition.
And there is no communication between you and the claimant about the claimant's resignation until the 21st of April. That's right, isn't it?
In writing, but we had several meetings.
You had what, sorry?
Several meetings, discussions about the matter.
Several discussions.
Discussions, yeah, because I used to go to office and he used to come to office.
So, what's your evidence then about this waiver letter? What was the claimant's position?
Clearly that, again, this is before his resignation, when I was going to the
About
States.
March. I'm talking about February, March. He's resigned.
Yes.
You invite him to sign the waiver letter, the company does, to forego his last instalment of LTIP.
He always demonstrated that this is not an issue that he will have problems with the waiver for the 50%. He always supported that.
Him personally, or he supported the defendant's actions in trying to compromise these claims with the other employees?
For everybody. For him and the others.
So then why did he not sign the letter?
Ask him.
I'm asking you because, Mr. Mshahwa, what you say just simply doesn't make sense. Your letter of the 21st of April tab 180.
Yes.
You say then that I refer to a letter dated 30th of January and your subsequent decision to stay with Dubai Aerospace Enterprise. Following our various discussions for the sake of good order, I write to confirm these discussions. The claimant, and you were well aware of this, had made no decision to stay with the defendant.
You're asking me?
Yes.
Clearly, I was under the impression and the understanding that he was staying with the AE.
Okay. You were under the impression. What gave you that impression?
My discussions with Mustafa.
What did he say to you?
That, again, this was not an issue that we should worry about.
So he said it's not an issue we would worry about. What? I thought you said that was in relation to the waiver letter.
Yeah, the 50% definitely.
Yeah, but I'm talking about his decision to stay with the defendant. He said, "Don't worry, it's nothing you don't have to worry about."
Yeah, this is all of these, like it's all just to push for action from his side.
All right. So he said, "Don't worry about it." That's all he said to you, and you took that to mean that he was retracting his resignation.
No, definitely not.
Okay.
We had several discussions on the issue, and again,
Mr. Mshahwa, you keep saying you had several discussions.
of course, because it was the 2011, that's 2 years ago, 3 years ago. But clearly, I'm clear in my mind on this one. And again, this was my understanding.
Well,
Maybe he meant something else, but my understanding was he like this resignation is not to continue, and he would continue till October
Right.
of 2011.
And that's what I'm trying to get to the bottom of, your understanding. Your understanding was as a result of the claimant saying to you, don't worry about it. Let's get on with it.
Plus all the discussions.
Yeah, let's just pause. All the discussions. About how many discussions do you say you had?
I used to go daily to DAE.
Pardon?
I used to go daily to DAE
Okay,
because I had another responsibility at that time.
okay. And in all of these discussions, are you saying that he simply said to you, don't worry about it? Is that what he said about his resignation?
No, we discussed this resignation and we discussed still the continuation of the employment, even the part-time one.
Yeah, you discussed it. What I'm trying to get at is, what did the claimant say to you in words, in terms, because you clearly remember it, that gave you the understanding that he was going to retract his resignation? Sorry, is everything okay?
Fine,
Good.
keep going.
Again, I'm sorry.
What did he say to you in terms to give you the understanding that he was retracting his resignation?
Again, clearly, the different discussions and the fact that we were discussing his continuation till October and for the part-time, all of these things, no one will discuss with you his like continue till October on the part-time and he's continuing to resign. Again, that was the essence of the discussions at the time, and clearly.
Yeah, about
And the allowances issue from day one, I was clear with Mustafa that they will be reinstated, and it is a matter of time, and we have to work together to find a way to approach the managing director with this one.
So are you saying then the discussions were the claimant considering maybe staying until the end of his term and maybe considering that he may provide his services as consultant?
After the contract
Yes.
expiry.
So because he was considering it, that's where your understanding came from?
And again, it's not definitely, it's not only there were continuous discussions, and I know you don't, it's ongoing discussions with me and Mustafa at least twice a week that we discuss this issue, and I know that the issue was on top of his head, and we constantly addressed it and tried to find ways to overcome this obstacle.
Yeah, and so it was him saying, I will consider this. Is that where you get your understanding from?
I cannot tell you the exact words.
No.
Was it a very heated meeting or a very
No.
relaxed meeting?
No, never heated me.
Never heated.
No.
Because he immediately writes back to you, doesn't he? Following this letter of the 21st of April.
Yes.
And he says to you, tab 185 D3,
Yes.
he says to you in terms, the notice of termination of my employment agreement with DAE pursuant to clause 12.11 of the subject agreement as outlined in my letter dated the 30th of January 2011, and that's his termination letter, has not been withdrawn. And at no instances have I agreed to remain with DAE for the remainder of my current employment term, as alleged in your letter. So that really fits with what you're saying, isn't it? He was considering, but at no point did he withdraw his letter of termination.
Again, withdraw? No, but understand that he will withdraw? Yes.
He will consider.
No, it was that he will withdraw. My understanding that he will withdraw.
But he didn't.
He didn't.
I clearly outlined the reasons for serving that written notice of termination as a persistent breach of a number of material provisions of the subject agreement, including but not limited to the withholding and non-payment of several of my contractual entitlements as stipulated in the subject agreement. Although you're fully aware of these various persistent breaches, let me list a few for your ease of reference. And what he says, the first one is, the prolonged postponement in paying employment year 2 long-term bonus and the phasing of the same in 2 equal instalments contrary to the terms of the employment agreement. So you said you needed to have discussions every day. In these discussions, he told you, didn't he? Look, I'm not happy about the prolonged postponement of my year 2 long-term bonus. He told you that, didn't he?
This was his suggestion to do this in 2 payments.
Yeah.
This is the first 15% of LTIP. He was head of HR, and this was part of his tasks.
Ms. Mushawa, what I'm asking you is that he told you that, didn't he?
I don't remember. No, seriously, I don't. The discussions never went to discuss the LTIPs or the waiver, whatever, all of it. But again, it's,
So he may
these
have
are
done-
legal letters going back and forth. Yeah.
Yeah, so he may have done, but you don't remember.
No, I don't remember.
Fair. Second point, and again you may not remember this, but he did tell you as part of these discussions that the reason for his termination was also the withholding of non-payment of employment year 3 annual bonus entitlements as stipulated in the employment agreement.
No.
No, you don't
No,
remember?
I don't remember at all. It's like these, again, the only thing was the allowance, and we had several discussions, and I don't remember him having issues with these things, because these were part of his responsibility, and he was aware, and he led the NRC meetings or the executive meetings or whatever. So he was involved in the whole process. It's not that we paid everybody else and we didn't pay him.
Yes, but Ms. Mushawa, you've got to remember, he may have been involved in the process, but this is at a point where he is, or he has resigned. So, in these discussions, it's perfectly plausible, isn't it, that as an agreed employee, ex-employee, he's telling you that these are my grievances.
In the letter. But
you
before
don't
that, I don't remember.
So
No.
you could have done, but you don't remember. What about paragraph 3?
Can you answer that question?
So he could have done, but you don't remember.
I don't remember him addressing it before this letter.
Right. And number 4, you knew about that, didn't you?
Yes, the allowances.
The next paragraph, he talks about the further example of your contempt for the terms of the employment agreement, as you have no rights to assign conditions for the reinstatement of these unlawfully withheld contractual benefits. You see that there?
A further example of your contempt for the terms of the employment contract, as you have no rights to assign conditions for the reinstatement of these unlawfully withheld contractual benefits. Yeah, I see that.
Yeah? And he actually refers to a date that a discussion took place, the 21st of March 2011. Now that was the discussion before you sent in the 23rd of March email. Yeah?
Mm-hmm.
You have informed me that you have sought and received your legal counsel's advice and confirmation that the payment of these withheld allowances actually constituted a binding amendment to my employment agreement.
Oh dear.
So,
Yeah?
discussion with you on 21st, you have informed me that you have sought to receive. This is the email of the 23rd.
Yeah?
Yeah.
This discussion, 21st of March discussion that the claimant is referring to, is before the email that you sent him on the 23rd of March.
Definitely, I would have had a discussion with him. What the content was. Definitely, I would have told him that you will receive an email, so we will reinstate the allowances.
Furthermore, you've written to me on the 23rd of March stating that considering the previous CEO approval and since this constitutes an amendment to contract, the Managing Director has approved the release of the allowance provision to you, which will be payable on monthly equal instalments retroactive from November 2010. And he repeats there the email of the 23rd of March. Yeah?
This is, yeah, the
And
March 23rd.
And then he makes the point to you, doesn't he? Ironically, there is no mention in your correspondence that the reinstatement of these withheld allowances is contingent upon my agreement to remain with the company for the remainder of the employment agreement. So he makes that point to you, doesn't he?
Yeah.
And the reason is because it wasn't contingent upon him remaining with the company.
Again, this was the understanding of me at the time.
In another outrageous manipulation of the facts, you stated in your letter that you urged me to consider remaining with the company for a period of employment beyond the 11th of October 2011, although I indicated to you that I had another job offer in Abu Dhabi and therefore did not want to discuss further employment at this stage. That's what happened, isn't it?
That's what happened?
Yes.
No. Again, these letters, everybody was putting his position now very clear. It is clear in my mind what we discussed, and again, I tell you, it is my understanding that he was continuing with the company, and we discussed the issue of him continuing after October.
Well,
Now, these letters are positioning letters.
the positioning letters, are they? Well, they're contemporaneous documents, aren't they? They're
I'm sorry?
closer. They're documents that are closer in time to what was going on. Yeah?
And
so
then there was the letter
suggest
of
to you-
April 21st also.
I beg your pardon?
The letter of April 21st also, that
Yeah.
he would not continue, he will continue with the company. That was the understanding at the time.
And I'm going to suggest to you that what is set out in this letter in terms of the facts is actually what happened.
No.
No? Well, if it didn't then, why did you not respond in terms to this letter and say, don't agree with what you're saying there actually, it's a travesty of the truth, this didn't happen, and respond to the factual content of this letter?
Because the letter of 21st of April reflected the opinion that we...
Yeah, but he's writing to you, he's disputing your version of events, but you don't write back and say, I don't agree with what you're saying on the 27th of April, I'm sorry.
Yes, he does. I'm sorry, that's confused. We better take him to the correspondence if you want to sit down. It's exactly what it is.
You don't say, in terms, the facts that you are expressing in this letter of the 27th of April, I disagree with.
Well, she needs to take the witness to the letter at tab 189 if she's going to make that submission, make that ask that question.
Well, the letter at 189 is short, but doesn't accept the previous letter.
And it reiterates the position in the earlier letter. So it's quite wrong for a learned friend to suggest to this witness without showing him that letter that he didn't respond rejecting what that letter says. It's
Page-
the next day.
What you do not accept is that the company is in breach, as asserted by you, of the terms of his contract. That's what you don't accept.
And irritating the position of the 21st of April.
You don't say in terms about the discussions on the 21st of March 2011 and what took place.
March 23rd
March
reflecting.
21st.
Yeah, I know, but the March 23rd email subsequent came after the March 21st meeting,
Yeah.
where we reinstated the allowances.
And where the claimant sets out his position in his letter of the 27th of April about what occurred on the 21st of March 2011, yeah?
He said that I would reinstate the allowances.
Yeah, let's go back to 744.
744. Yeah.
You don't disagree in terms about what the claimant is suggesting happened on the 21st of March 2011.
But what happened December, March 21st was confirmed in the March 23rd email. Reinstatement of allowances. This is what happened.
The letter
What
on page
else?
744, the last paragraph, I reiterate the company's position as stated in our letter of the 21st of April 2011, namely, your purported letter of notice dated the 30th of January is no longer effective. What you are saying there is you're reiterating the position of the 21st of April in relation to the letter of termination dated the 30th of January 2011. That's what you're saying there, isn't it?
Letter of termination. What tab is the April 21st letter?
That is tab 180.
So in the April 28th, I confirm what came in the April 21st.
Yeah, but what you say in relation to your confirmation, in your letter of the 28th of April, you say, I reiterate the company's position as stated in our letter of 21st of April, namely your purported letter of notice dated the 30th of January is no longer effective. What you're seeking to do there is simply say that we don't accept your letter of termination of the 30th of January is effective.
Based on the understanding that it's not effective.
Yeah.
Again, in the survey discussions, subsequent decision to stay with the aerospace and following our various discussions, for the sake of good order, I write to confirm those discussions. So,
You then suggest to the claimant that you look forward to his attendance on the 1st of May. Prior to the 1st of May, the claimant writes to you on the 28th of April, doesn't he? Tab 7, page 747, tab 191.
yes, I
Do
see
you have that, Mr.
It's the
Mushawa?
email, yeah.
Yeah. And it's telling you the HR handover that he wants to conduct with you, isn't it?
Yes, this is what the email says.
Yeah.
HR handover.
He tells you, doesn't he, that he was responsible for the safekeeping of various files and documents, both in hard copies and electronic formats. You knew, didn't you, that the claimant had a handheld storage device?
What do you mean handheld storage
Like
device?
a flash
USB?
drive? Yes, USB.
Everyone has USBs. Yeah.
Everyone has. And you knew that he used that USB for his work.
No,
So in what
it's
context?
not specifically that Mustafa uses. Everybody has USB, so he can use whatever he wants. But
Yeah.
I didn't know specifically that this USB is for Mustafa and for his work in
But you
particular.
knew he had one and you used it at work.
No,
So how did you know he had one?
everyone uses USBs. I'm not saying that Mustafa had USB. It's a common device.
He also tells you that as a result of downsizing the HR department, there's only one remaining junior employee in HR, which is Sharif. And that's correct. There was only one remaining junior employee. wasn't
Sharif,
there?
yeah.
And he was very junior, wasn't he?
Junior, yeah.
Well,
Yeah,
very
but he's
junior.
been with the company for a long time.
Yeah, but in terms of grading, he was right at the bottom of the grade.
But he was reported to Mustafa.
Yeah, I'm not. Mr. Shahwal.
So because there were only two people,
Yeah.
him and Mustafa.
But he was at a very low level grade, wasn't he?
It's, yeah,
Yeah.
like an accountant, same level as
Well,
accountants.
Would you say that? He wasn't he just simply there handling issues of visas and permits and car park spaces? Isn't that what his job was?
Among other things, yeah.
What was
HR
it?
issues
Right.
and
Tell
these
me.
things.
You tell me what those amongst other things are.
Payroll, all of these things, he used to report to Mustafa.
Yeah.
So
there-
HR issues plus these things, again, because of the number of employees, limited tasks, so we didn't need more than
Yeah.
this.
So not really roles of significant responsibility.
And that's what I'm saying,
Paperwork,
an accountant.
admin- Pardon?
Yeah, accountant, admin, yeah, true.
Yeah, admin, sorting out.
Not a PRO.
Yeah.
Definitely higher than a PRO.
Sorting out permits, visas, and so forth.
Plus, yeah.
Yeah. And the claimant was very sensitive, wasn't he, about not compromising confidential information of employees.
As part of his role, I would assume he
Yes.
is, of course.
And so you can understand why he didn't want to pass over very confidential information sensitive information to a very junior employee.
Maybe I would understand that.
Yeah. And so it's quite appropriate, isn't it, for him to safeguard the integrity of documents within his custody.
Again, it's his responsibility to safeguard it. How to do it, that's a different thing.
Yeah.
It's a responsibility, definitely.
Yeah, but nobody's told him how to do it, have they?
I'm sorry?
Nobody's told him that when you leave, this is how you safeguard.
Because we expected him in office on May 1st.
No, that's not the question, Mr. Mushawa. The question was, nobody told him how to safeguard the integrity of these documents on leaving the company.
No, he's a chief.
Right. So, he tells you, in the penultimate paragraph, that these documents are under lock and key, ready for handover. Yeah?
I'm sorry, which paragraph?
The second to last paragraph.
Yes.
So nobody's told him how he needs to conduct this handover. He's the guardian of very sensitive confidential information. I mean, for him to take a decision to put it under lock and key, there's actually nothing wrong with that, is there?
He's a chief, yeah.
Yeah.
He's responsible.
Yeah. And so putting it under lock and key is him doing his best to safeguard these very confidential, sensitive documents. Yes?
I believe so, yeah.
Yes. He also tells you that there's a number of HR activities and tasks that will require urgent follow-up in the future. Please let me know who you wish me to hand over these files to and with whom shall I discuss the ongoing HR workflow, preferably a senior employee. I am ready to commence the proposed handover immediately today, however I can avail myself another day should this be more convenient. Now, understandably there was a lot going on. But even so, you didn't respond to the claimant, did you? And tell him who he should hand over to, who he should discuss the ongoing HR workflow with, and what needs to be done in relation to the handover.
I don't remember.
No.
Yes.
Well,
I
you
believe the
write
letter
him on
of
the 4th
28 was
you-
subsequent to that.
Well, you write to him on the 4th of May 2011. Tab 7, page 748, tab 192.
Yeah.
And in this letter, you don't tell him, do you, who he needs to hand over to, who he needs to discuss the ongoing HR work with, and how handover needs to take place.
Because there is no handover. He's an employee of DAE at the time. The understanding was on the 28th or 21st that he's continuing as an employee of DAE.
Oh, so you say that because you're under the impression that he's still an employee, you're prepared not to undertake any sort of handover with him. You're not going to engage with him on this handover. Is that what you're saying, Mr. Mushawa?
May 4th, I referred to our letter dated 28th of April.
Yeah.
As you're aware, DAE considers that it has received no effective termination letter from you and you remain an employee of DAE to date.
I understand.
So,
Yes. So are you saying then, is your evidence that you weren't going to engage with the claimant on this handover process because you still considered him as an employee?
and he did not attend to the office, yeah?
Yes?
Yes.
Yes. Okay. So the claimant could have done anything in relation to this handover, but the defendant wasn't going to accept it. Hmm?
I don't know what would have happened. Yeah.
Right. Page 748. In addition, I'm looking at the last paragraph. In addition, as you are aware, DAEIT has been carrying out a system review. This is due to concerns over the integrity of a number of electronic files. You are required to cooperate fully with any queries DAE may have regarding this matter, and I will inform you if we wish to speak to you concerning the same. First thing, Mr. Sharma, the IT review, the system review that was being carried out, was there any report in relation to this IT review?
I don't remember.
You don't remember. You say that this is due to concerns over the integrity of a number of electronic files. You don't tell the claimant in that letter. You don't tell the claimant in that letter, do you, that the concerns in relation to the integrity of the electronic files is anything to do with him?
No, I say I will inform you if we wish to speak to you concerning the same.
Yeah. That's a separate sentence. I'm asking you about this is due to concerns over the integrity of a number of electronic files. You don't say to him, in terms, do you, that actually the concerns that we have about the integrity of a number of electronic files is because of you.
He doesn't say that, no.
No, it doesn't say that.
Expecting his full cooperation.
No. And the reason why you don't say that is because there were no concerns in relation to the claimant at that point, was there?
Because they were
and,
carrying
and,
out.
and the integrity of electronic files.
I don't know, because there was like a system review being carried out, and that if there are any queries, we expect his cooperation, and I will tell him when we would need him to speak to him.
Fine, there may have been a system review carried out, but Ms. Michelle, my question is different to what you just responded to. What I'm saying to you and what I'm asking you is this, that you don't tell the claimant that there is a concern regarding the integrity of electronic files, specifically because it has anything to do with the claimant.
Definitely, that's why we write to him. This is the review. There's a system review,
Yes.
and this is due to concerns over the integrity of number of electronic files. You're required to cooperate, and then we'll speak to you. So, as a result of the review, but definitely there is something related to Mustafa. Otherwise, why would I write this to him?
Yeah, but you're saying that there's a general system review. Generally, there is a system review. You do not, and you can't say that you do. You don't say to Mr. in that letter, something to do with you.
It might be.
No, that's not what you say there.
Yeah, but that's why we need to talk to him. That because we didn't have conclusive decision at the time, maybe.
So it might be. Is that your evidence? That it might be something
Because
to do with him.
and I will inform you if we wish to speak to you concerning the same.
Yeah, but you don't say, do you? It has specifically got something to do with something you may have done to the computer service.
Depending on the review.
Depending upon the review.
Review, yeah. The review will dictate.
The review will dictate.
Yeah.
Right? So when do you say this review dictated that it had something to do with the claimant?
I don't remember, I'm sorry.
You don't remember?
No.
I'm going to suggest to you, Mr. Mushamra, that in fact, at that point in time, 4th of May 2011, you had absolutely no concerns about your system or about the claimant having done anything to compromise the integrity of your system at that time.
You're saying?
What I'm saying is that as of the 4th of May 2011, you had no concern about the claimant compromising your electronic files.
But this is what the letter says.
No, it doesn't.
It says that there's a review being conducted. We'll call you if we need you, and we expect you to
Right.
cooperate.
Okay, well let's move with that then.
Yeah.
we will call you if we need you to cooperate. Are you saying?
No,
There's-
you'll cooperate, we'll need you if, call speak to you concerning the same.
Yeah. So are you saying in that letter that we will speak to you only if we think that you might be either A, responsible, or B, that you might be able to help us?
This is what I would understand
Right.
from this.
And the fact of the matter is that you didn't invite him, did you, to come and speak to you? You didn't invite him to come and speak to you, did you?
I don't remember.
Well,
I
I
have to
can
check.
tell you that there is no document, there is no letter, there is no email saying that you asking the claimant to come and help you with any of this.
If you say so.
So you didn't.
I don't remember.
And given you didn't ask him to come and speak to you in relation to this, you must have known at that time that A, he wasn't responsible, and two, that he can't help you with anything.
I don't know.
And the reason why is because, as it says quite clearly in this letter, there may have been a system review, but it was nothing to do with the claimant.
This is particularly misleading because, in evidence, Mr. Al-Hendi himself admitted that a week or two earlier he'd been removing files from the system and replacing them, and there's an email exchange in the bundle where he specifically asked, can you tell me what's happened to these folders? So it's very misleading from a learned friend, without putting that to this witness, to ask this question that there was nothing to do with the claimant in relation to IT.
Well, my lord, it's a dispute of fact whether or not anything that the claimant did compromise the integrity of the defendant's system.
Well, you can remind him of that in the re-examination.
Did you know, or were you aware at that time that the claimant was removing or deleting or modifying files on the defendant's computer system?
I don't remember, no.
Sorry, you don't remember whether you were aware of that at the time, or you don't remember whether you was doing it or what?
I know that there was something, that's why there was a system review, but I don't remember exactly what's the result of this.
Okay. Do you remember what the allegation was? What the concern was?
Moving confidential information, or using it like, this is company information, using it for himself.
That was the concern at the time, was it? Or are you just saying that because you read the pleadings and you know that to be the case of the defendant's case now?
Not at all.
So, okay, let me get this straight. At the time, you had concerns that he had been doing what?
Compromising the integrity of the information.
How?
This is why we had a system review done.
No, how?
And again,
how,
this-
Mr. Mashawar, was he compromising the integrity? Tell me how.
Whether with taking copies, whether with deleting copies, whether taking emails or deleting emails. I don't know. This is a system review. It's not more for me to decide. But definitely there was doubts on the IT level.
Right. So you knew that at the time that you wrote this letter, 4th of May.
This is what it says, yeah?
Right. Quite serious, isn't it, in terms of an allegation against an employee?
That's why it says you have to cooperate, and we'll tell you if we need to.
So why did you not then inform him that you wished to speak to him concerning the same?
Definitely, at the time, the investigation was not, or the review was not complete. Otherwise, I would tell him that we need to speak to you to so and so.
But you know at that point that he's either taking copies or deleting emails. That's what your evidence is.
This is concerns.
Yes.
Yeah, we
so
have
why
concerns.
not? You have concerns. Why not invite him in and speak to him about your concerns?
We told him that once we are ready, we'll call you. This is what it says.
When were you going to be ready?
I don't know at the time. How long would it take?
And it doesn't say once we're ready, does it? It says you're required to cooperate fully with any queries dear you may have regarding this matter, and I will inform you if we wish to speak to you concerning the same. You didn't inform him that you wished to speak to him, and I'm going to suggest to you that in actual fact, you didn't know at this time that there were any concerns in relation to the claimant and the defendant's computer systems.
I signed this letter. That's my signature there.
And had you had serious concerns, as you now say, you would have invited the claimant in and you would have wanted to speak to him.
It depends on the readiness of when to speak to him, whether the review is done or complete or whatever.
When do you say the review was complete then?
I don't know, I don't remember.
You don't
It
remember?
doesn't say there. It
No, I
says
know
that
it doesn't say. From what you know, from what you're aware, what you can remember, when do you say the review was over?
I'm sorry, I don't remember.
You don't remember?
No.
Do you remember from where you got information which led you to write about concerns over the integrity of a number of electronic files? Where did you get that information from?
I'm sorry.
Because you weren't managing the electronic files.
No, definitely not.
So where did you get the information from?
Maybe from Bijou, maybe from Feroz, maybe from, definitely somebody found out something and it triggered this concern.
And mentioned it to you?
Yeah, of course.
You also say in this letter of the 4th of May that with regards to the locked cabinets, it's not acceptable for the files to be inaccessible. Yeah?
Yes.
The claimant then writes to you, page 750.
Uh-huh.
Yeah? And he says to you, on the 28th of April, I offer to hand over to you or your nominated representative various files and documents, both in hard copies and electronic formats, that are under my custody to which I did not receive any response. I'm ready to come to Dubai tomorrow for the subject handover only, so please confirm your availability tomorrow at 10 a.m. to receive and sign all items to be handed over, all of which are kept under lock and key at the DAE offices ready for handover. He invites you to confirm, doesn't he, that meet me on the following day at the 10th of May.
On the 5th of May. Then,
Sorry, the 5th of May, yes.
this is what it says, the email, I remember this
Yeah.
email.
But you don't take him up on that offer, do you? Because you don't say, okay, I'll meet you tomorrow on the 5th of May.
I don't know whether I was available or not at the time.
No, but you don't even write to him, do you? So, if it was that unacceptable for files to be under lock and key, and if you had real concerns about the integrity of your system, I'm going to suggest to you that you or another representative of DAE would have taken up the claimant on his offer to come and meet on the 5th of May to conduct a handover.
If the 4th of May the review was not done, definitely the 5th of May it would have been done.
Yes, but
Still the review is
irrespective-
ongoing.
Irrespective of whether or not the review is done, you have at that stage, your evidence is, concerns with the claimant. You also say that it's unacceptable for files to be under lock and key.
Hard copies, yes.
Yeah. Here you have a perfect opportunity provided to the defendant by the claimant to meet, to conduct a proper handover and to discuss any concerns the defendant has. The defendant fails to take up the claimant on this opportunity, doesn't it?
If there's no response.
Yeah. And the reason why the defendant fails to take up the claimant on this opportunity is because I'm going to suggest to you, Mr. Mushawan, is that defendant was setting up the claimant.
Definitely not.
definitely not. Page 752. It's a letter again written by you. Third paragraph, no further monies are due to you. I'm going to suggest to you that the defendant, knowing that the senior HR function was redundant, was in fact settling the claimant. The reason was because it didn't want to pay the claimant any monies that were properly due to him.
Definitely not.
And that's why it set about to make allegations against the claimant of dishonesty and set about making these various allegations about the integrity of its system because it simply doesn't want to pay Mr. Al-Hindi what is
We wanted
due
Mr.
and
Hindi-
owing to him.
We want Mr. Hindi to continue. That's very clear. Never. This conspiracy theory is not there in my mind.
Well, the defendant's conspiracy that Mr. Al-Hindi compromised the defendant's systems. Mr. Mushawa, if that's right, why was that never ever raised with the claimant until April of last year?
Yeah, this is a technical issue, and from that time on, it was an issue between legal and the. It was not a management issue for me.
Because it's within the defendant's policies, isn't it, that where there is an allegation of this nature, it ought to be investigated with the employee.
Again, this is like any other company. If there are allegations to get with the employee.
Yeah, dealt with the employee. But yet you fail to follow your own policy on this by failing to investigate with your employee, with Mr. Al-Hindi.
When?
When? Around about this time.
I don't know when the review was done. It says that there's a review and there's a concern of integrity, and we'll call you once we're ready.
It's not only in this instance that you fail to follow your own policy, but also in relation to the termination of the claimant's employment. Yeah? Who made the decision to terminate the claimant's employment?
Again, I'm sorry.
Who made the decision to terminate the claimant's employment?
This is letter of 10th of May.
I'm asking you, who made the decision to terminate the claimant's employment?
Definitely, this was a legal issue and would have been discussed with the managing director, with myself also.
Right. So, who made the decision? Not who had the discussion, who made the decision to terminate the claimant's employment?
It's very clear. He did not attend to the office and it was terminated.
Mr. Mushawa, I'm sorry.
You're asking me who made it?
Who made the
Definitely.
decision?
It's either me or Khalifa. But most probably Khalifa would know this as an MD.
Either you or Mr. Al-Daboos?
Mr. Al-Daboos, yeah.
Right. So
I
you're
can't
taking
remember
steps
exactly.
to terminate an individual's employment, his livelihood, and you don't know who made the decision. It's a very simple question, Mr. Mushawa. Who made the decision?
I'm telling you, at the time, it's CEO and the MD.
So you and Mr. Al-Daboos.
Definitely, we will discuss these things.
Okay. And basis of terminating the claimant's employment?
I don't remember at the time, but it says here for failing to attend to office.
Okay, it says that in the letter.
Yeah.
Yes. But what do you say? Being the person who was jointly responsible with Mr. Alderbous for terminating the claimant's employment, what do you say was the reason for termination?
Again, the same thing. We did not consider the resignation as valid, and he did not he failed to attend to the office.
And if you can pick up D1, please. Tab 18. This is the Employees Policy Handbook.
1.8. Yes.
Can I ask you to turn to page 119?
Yes.
This talks about disciplinary measures at paragraph 13, 120. Yeah? Can you see that?
119, 120.
120. Can you see 13.1? There's a note there. No penalisation shall be applied on an employee unless and until an investigation has been conducted. The employee shall be given the chance to appeal and defend himself or herself. Now, you and Mr. Debus terminated the claimant's employment because he failed to turn up to work. Yes?
This employee handbook still shows the 60 entities.
Right.
So this is 2007.
Right.
We are 2011.
Well, this is
The
a document.
changes is.
Well, this is a document that the defendants have disclosed, so presumably this must be the applicable policy, unless you can tell us
It
otherwise.
shows capital, manufacturing, university,
Yeah.
airports, engineering services.
Mr. Michelle, this is the policy that defendants have disclosed. But you now say that there's a different policy that's applicable.
It's not necessarily different policy, different terms, but fine, no problem.
Okay.
Continue.
So, Mr. Mouchahua, you and Mr. Alderbous terminated the claimant's employment for failure to attend work. So tell me this. Why was it that a penalisation, in this instance a dismissal, was applied to the claimant without there being an investigation and without the claimant being given the chance to appeal and defend himself?
My lord, this isn't an unfair dismissal
No, I know
claim,
it's
and
not.
although it's gone on for a while, I cannot for the life of me imagine which issue this all goes to.
It's a permissible question.
Thank you.
Again, please.
When coming to terminate the claimant's employment, there was no investigation that he had failed to attend work, nor was he given the chance to appeal and defend himself. That's right, isn't it?
But he failed to attend work, but that's fine. There's
Yeah.
no investigation. He failed to attend work.
Yeah.
I don't think there's a need for investigation. And at the time, we took the decision to terminate based on
Yeah.
this.
And I'm going to suggest to you that there was a non-compliance with this policy. Yes or no? Was there a non-compliance?
For the red, yeah, maybe.
Are you saying yes, there was?
Well, my lord,
Yeah,
if this is relevant, it's for your
It's-
lordship.
Did you know about the policy at the time?
No. Again, this is 2007. Lots of things changed.
Well, it's 2007. Had this ever been brought to your attention at the time in May 2011 when these letters were written?
No.
Well, there we go.
So you're responsible for the executive team. You're responsible for managing the executive team. But yet you don't know what policy applies to the executive team. Is that what you're saying? As an acting CEO,
Yeah, because usually
you
HR
have no
advises
idea about...
us.
Pardon?
Because usually HR advises me on these things.
Yes. And the
And
person who
HR.
has knowledge of HR, that was the evidence that you gave yesterday, you have no idea whatsoever that there is an employment policy or a policy applying to employees.
No.
Had you even bothered to see whether or not there was a policy that's applicable?
No.
No, you hadn't even bothered to do that. You tell the claimant to attend the offices of Altamini. Thank you, Mr. Thompson. Thank you. Thank you. You tell the claimant to attend the offices of Altamini for the purposes of handing over certain company property. Yeah?
Yes. So this is the 10th of May letter, right?
Pardon?
10th of May letter?
Well, we don't need to go through a letter. Do you remember that happening or not?
Yeah, we requested to attend to the
And
office
being
of
pressed
the
for
meeting.
time by your counsel, so let's not go to that.
You're not being pressed for time by council. I was just saying to my learned friend very quietly, sotto voce, as is polite in these circumstances, whether she noted the hour. That's the only thing I said. My learned friend shouldn't read too much into that. It's politeness.
I'm just going to rise for a short term, very short term.
All right. Stevie, I'm not getting excited. You're obviously very nice to me.
I'm not worried about the time. The judge likes to break your one, and I don't know whether when you cross-examine you notice the time. I don't. Okay, fine, you do. But don't think it's a personal insult or I'm making some point about cross-examination. No, it's an invitation for you to relax a little about what I'm saying.
I'm perfectly relaxed. Yeah.
How much more have you got? No idea. Because George was told he could go after lunch, and so 11:30 he thought it was an hour. So can we have some idea? It's not fair on George.
No, I don't know.
You have no idea.
No.
It's only your microphone that makes the noise. Is it, do you only do microphone to make it noise, or is it just the witness one?
It's just coming out.
Feedback.
But it's
We
mostly.
don't know the source. This is coming out of the speak.
It seems to me when you haven't got any
Devices.
devices.
I mean, the system is there.
Let me just put it as
Okay. We'll send our IT in during lunch to see if they know.
George, what's your commitments this afternoon? Do you have anything?
Yeah.
What time's your last possible time?
I have a 2 o'clock
In the IC?
in NS House.
In
NS House.
MS.
Yeah, of course.
Yeah. Okay. Can you come back after?
I think you'll be able to make it.
Yeah.
turn the air conditioning on here. Incredibly off. Yes.
Mr. Shamrock, can I ask you to turn to D3198, please? This is a letter from KBH to you. It's telling you that the representative for the claimant will attend at Tamimi's offices with the following items A to E. Did you see that?
Yes, I see it.
There is then a response from Ms. Jones at page 759, where Ms. Jones acknowledges receipt of all those items at A, B, D and E. And D and E is the key to the claimant's office and to his filing cabinet. Yeah?
This is what it says, yeah.
Yeah. Who picked up the key from Tamimi's offices? Do you know?
No, I'm sorry, I don't.
And do you know who used that key and opened the claimant's office?
No, I'm sorry.
You don't know.
Do you know anything about what happened about documents or electronic equipment after the 4th of May?
To be frank, no. It was a matter, technical matter and a legal matter that I was little involved in.
Don't think you need to ask any questions about that area.
Thank you. Sorry, Lord, if I can just perhaps turn my... Yeah. My Lord, I don't have any further questions. Thank you, Mr. Michelle.
Thank
How did
you.
you make your appointment?
Thanks.
My Lord, Mr. Meshwara has a 2 o'clock appointment
Yeah, I
at
know.
the Emirates Towers.
Yeah.
I've got 4 questions in re-examination. If your Lordship will indulge me,
You mean you want me to keep quiet?
Well, I will. No.
I'm quite happy to do that.
I just wanted you allowed to ask the questions. You can add to them and improve them as we go
Yeah,
along.
I know. I tell you, it takes exactly 8 minutes to walk from this room to the Emirates Towers. I do it every day,
Right.
twice. So,
Mr. Kushwaha, I just have a very few questions to ask you, following on from the ones my learned friend asked you. Could you look first in bundle D3, tab 111, document you looked at yesterday?
Yes, I have.
And on page 5, do you remember this email? This was one from Mustafa Hendy to you in April 2009. It's quite a long email, but it sets out, it describes itself as a formal HR opinion. And in particular, yesterday you were asked to focus on the paragraphs at the top of page 544.
Yes.
And in particular, there's a paragraph at the start, bonus payment for the second category contingent on the achievement of pre-negotiated MBOs. However, HR records show only some names and Al-Hendy to have some form of approved annual performance target of the year 2008. And you were asked to identify anything within that email with which you took an issue, knowing what you know now and having seen the contract. That was the question that was put to you. I just want to show you a couple of documents and ask you that question again. Firstly, could you have a look at your own witness statement, which is behind tab 12 in C2. just want to take you to paragraph 32 of that witness statement, which is at page 417.
Yes.
And you're explaining in that paragraph, as the second sentence I'm interested in, that so far as you were aware, reference to MBOs and key performance indicators, KPIs, were used interchangeably by Mustafa senior management and the HR committee when discussing performance criteria and preconditions relevant to contractual terms relating to the payment of a bonus paid on the DAE group. And you say you certainly use the terms interchangeably, and you've explained that again in
Yes.
your evidence. Tell me, did you use those terms interchangeably before Mr. Al-Hendi joined DAE, or did you only start using them after he joined DAE?
Always objectives and KPIs are the same for me. So
Object-
I use even before.
Okay. Now, you were taken to this document, but I just want to show you briefly what it is that Mr. Al-Hendi says in his legal claim. You may not have looked at this folder, so I may want to show you one line. It's in bundle A1, which might be best if you have A1. Could you just turn to page 103, please? I'll tell you what this document is before I ask you anything. So page 103 is one of the pages of the legal particulars of claim that Mr. Al-Hendi is bringing. Now, there are different elements to this, but there's just one bit I wanted to show you, and that is in paragraph 11. Now, it says in the second sentence, which starts about 4 lines down, the claimant relies on the fact that no specific target MBOs and maximum MBOs were set by the defendant, and the defendant paid him and other employees a bonus by reference to 50% of their respective annual salaries in 08 and 09. So that is what the claimant says now is a fact upon which he relies, that no specific target MBOs and maximum MBOs were set evidently for 08 and 09, and that is put in distinction to the fact that he was paid a bonus for those 2 years, 08 and 09. Right. Bearing that in mind, and now looking again at Mr. Al-Hendi's email on page 544 of D3, is there anything that you take issue with in his email, knowing what you know now?
It says that the claimant relies on the fact that no specific targets in MBOs or maximum MBOs were set by the defendant, and the defendant paid to him the bonus. Here it says that these people and the lending have some form of approved annual performance targets for 2008.
Yes?
So here it says there are no specific, here it says there are approved annual performance targets of 2008.
That's right. So if the claimant's particulars of the claim are right, the document, the paragraph 11 that you're reading from, if that is right, would you take an issue with what is said in his email?
Yes.
And the issue would be?
Here there are some form of approved annual performance. Here there are no specific targets or maybe action bills set up by the defendant.
Thank you, Mr. Mishwala. I want to take you to another tab. You can put bundle A away. I want to take you to another tab of D3, behind tab 125.
Yes.
Now, you were shown this document earlier this morning, and you will recall that you were asked about the email, the second half of the page, from you
just
to...
pause. Half a minute, sorry.
I'm
Just,
sorry.
I hesitate to interrupt you. Can I just check out one thing? Just
Yes, of course. Mr. Mishra, at tab 125D3, there's that email that you sent to Mr. Ramadan, and you were asked about that this morning. Do you remember that?
Yes.
And you explained that this was based on discussions with the claimant, and it was then suggested to you, in a question from a learned friend, that you were, and I wrote down the precise words, advocating on behalf of the claimant completely independently. You weren't taken to the document immediately preceding that in bundle D3. Could you just have a look at tab 124 at page 578?
Yes.
Now, you see there's an email from Mustafa Al-Hendy to you, and it says, George, draft for your perusal, regards Mustafa, and then there's an email ABC headed Dear Nabil, and it has various paragraphs there dealing with various items. Now, comparing that document at page 578 with the document at 583, it's not in dispute that Mr. Al-Hendy drafted that email for you to send to Nabil, but bearing in mind the similarities and differences between those two emails, let me ask you again the question my little friend asked you. Were you advocating on behalf of the claimant completely independently?
It's very clear, and this was the practice that I used with Mustafa. He would write the draft for me based on our discussions and based on his opinion, and then I would review it and send it. If you can check between 124 and 125, minor changes between the two emails, the draft and what was sent.
Just help me with this. When you had discussions and then he drafted an email for you, as was your habit, did Mr. Al-Hendy simply take down what you told him, or did he himself discuss with you the content of what to write?
Basically, discuss with me the contents of what to write. And again, for these things, I would take his opinion on what does he think, and then I would tell him just draft the email and send it to him.
Could you go forward to another email I want to show you that you looked at today, at tab 157. There's actually two emails in tab 157, page 684. You were asked at some length about this situation, which was, you'll recall, the period after which the monthly cash payments to Mr. Al-Hendy had been stopped in lieu of his car and housing benefits. And you were taken to that email on the second half of the page, which is from him on January the 4th, must be about 6 weeks after you first told him you were stopping the payments. And it says, George, I note the concerns of the past 2 months my monthly wages have not been paid in full and a significant portion of the entitlement has been held without any official or proper explanation. What do you say about the phrase, without any official or proper explanation?
We stopped on the November 24th, and November 24th this issue was discussed and explained to Mustafa clearly what is it, what was it, and why it was like this. And I started from that point discussing with him options how to revive this allowance. So from day one, I gave him an explanation why we're stopping it.
From day one, you gave him an explanation as why you're stopping it. In the period between that day one in November and January the 4th, 2011, can you give the court an idea of roughly how many times you discussed it with him and explained your rationale to him?
At least 5 times.
5.
At least 5 times.
Now, can I take you to tab 185 of this bundle, please? Now, you were asked a few questions about this letter. This is the, to put it into context, the penultimate day of Mr. Al-Hendi's coming into the office, I'll do it that way. The 28th was his last day, this is the 27th. And you were asked several times about the reasons in your mind why the claimant had given his written notice of termination at the end of January. And you said, and I wrote it down, it's clear in my mind what we discussed. But it was suggested to you that in the middle of that page, paragraphs 1, 2 and 3, that those were also reasons which Mr. Al-Hendi had given you prior to this letter for why he thought DAE was in breach of contract. And in a series of questions, you were pressed and said you didn't remember him saying anything about those things. And then it was suggested to you at one point that he may have said those things and you had just forgotten. My question is this: what do you remember now about this? Do you say he could have said it and now you've forgotten? Or do you say you have no recollection whatsoever?
No recollection whatsoever.
Is it possible that he could have mentioned those things to you and you've simply forgotten?
I doubt it. I don't think so.
Explain to the court, please, how clearly you consider you remember these events.
Specifically, for example, for point 3, the non-payment of employment year long-term bonus entitlements as stated in the employment contract. We discussed that there will be no payments, and he is fine with it. So to come out and say that we discussed these as a precondition, no.
Do you say your recollection of these events that we're here discussing is a pretty clear recollection or not a very good recollection?
I mean, a very clear recollection.
Then, can I just take you to one two last documents, one last question. Behind tab 190 in this bundle D3, sorry, can we start at 191, the document you were taken to? Now this is an email, 8:32 a.m. on Mr. Al-Hendi's last day, the 28th of April. You were taken to this email. And you said, although it wasn't picked up by Malone Friend, it was picked up on the transcript, that you thought this email was before your letter of the 28th of April. Just go back to tab 190, please. You see page 745. There's an email from Leslie Jones copying you with a scanned PDF. Please see attached supplementary letter from George. And then over the page is a letter that clearly has been scanned, that has a signature on it.
Yes.
If you look at the time of that email,
1:43. On the same day in the afternoon, 1:03 to 4 p.m.
so although these pages are in the other order in this file, which should be chronological, but they're clearly, well, you tell me what you think the order
So
of
the
these was.
email was before we sent this letter.
Do you think you read the email at page 747 before you signed the letter at 746?
I might not have before.
Thank you. My Lord, I have no more questions for Mr. Mishra.
Right. Thank you very much for coming to give evidence. I've got no further questions, and this witness can now be released, I believe. Yes? Thank you very much.
Thank you very much, Mr. Michel. My Lord, Mr. Ramadan is due to come here at 2, but I imagine your Lordship will...
I'm going to sit again at 3.
Okay.
Is that, with the 2 hours, enough for him?
Your Honour, I hope to finish within...
Well, I'm not going to let him go part heard. He will be finished by 5.
Yes, Your Honour.
Okay.
I'll certainly work towards that timetable.
Right. Okay, good. 3 o'clock.
All right.
growing sound coming from the speakers. This one. Very, very big.
Yeah, it seems to be happening sometimes when he is speaking, and I think the witness. So I don't know if it's the microphone in the hearing or what it doesn't seem to. No, it doesn't. Just that one. I reckon it's that one, or maybe those two, maybe the witnesses. Yeah, that's.
Comes from mostly here, this desk. Mostly this microphones. And this one. Okay.
This one?
This one. And this one. Please check that. Yes?
That's like if you need to run on, then we'll need to you need to let us know exactly how much you want to have on,
So page 2.
and then let us know. to go to dinner tonight?
Yeah,
Yes, I'm going to. What do you think? What do you think? Something very, very, that was amazing. Because I put my feet up against his. Colder guy again.
Too much discussion.
Yes.
Every day.
Yeah.
do you want to keep going?
I'm
Or,
keeping
all right, so
going.
I'll go
Yeah.
have something, then I'll come back.
Yeah. Remember, it's at 3, so it's not.
Yeah.
So we have the 7th. That's why
In that case, we can make it 3 plus 1.
yeah.
Okay, for now, forever.
Okay. So it's
So now it's working, right?
yeah. You see, everything is fine.
Oh, what is that exactly? What's the issue?
I'm sure I just changed the system of operating to so you have to add host name.
Mm-hmm.
You need to add host name in order to enable discovery. When discovery is used, we are CRT ports or communication form or something like that. It's not like you want to just put some host name, enable of discovery, and we want you have to change from DPHP to just see device ID stands to 0. It's most probably we still see DPHP. Most probably some changes here. Instead of IP address and change device ID, it's happening from time to time. Anyways, it will match the configuration. It's created there already. And that is the problem in communication. The way that
So how to make the underscore?
just open like it will
Text underscore.
yeah, just like of discovery, space make underscore long. You'll just put this out like that. Anyways, you can just enable, just put some host name and we
Okay,
it's a small hint, so you usually have to take it.
So I need a small change here.
Yeah.
So now you can see 3 windows, right?
Yeah.
Can you please make it side by side and one full? Half full.
Sorry?
Side by side 1, 2,
Yeah.
and one full half.
Okay, so
So it will be called 3 windows, right?
so in 3.1,
Half.
you want to
You can make it side by side.
so let's just change.
Cheers. That's all. Okay. So we will be fine tuning that some Saturday we come and do the fine tuning. So Sunday we come and head out. Okay. And these are all fixed. So we'll change all the layouts in on Saturday and show you on Saturday. Okay.
I can come early on Sunday.
Huh.
And Sunday early, so we can have that.
Sunday session is there, right?
Yeah. Okay. Now, what about this session? Or I'll see you back.
that was quick.
I feel like I was outside for ages.
No. No, I haven't got too far. It's fine. I'm just. It's just so much over speaking. I'm
She is the one who did. She is the one who did it. They are inside you.
I'll get a coffee. Do you want a coffee?
Hmm?
Do you want a coffee? I might take you a coffee. You're right.
Maybe a Diet Coke? Just one Diet Coke.
tons of dogs. I know, it's unbelievable. It's worse than him.
I thought she was.
She was worse than him. A bit.
Nothing at all.
No.
I'll do a few dogs. Take my shoes off. Hope that fixed that audio. That's really strange. So we haven't had that problem all week. It's like they've made an adjustment overnight. You know, with the audio, we haven't had any feedback all week. It's a big problem.
Well, yeah, that makes sense.
Sorry?
Sorry. No, that's the only way you can do it. Sorry. Thank you.
Some.
Was there my Diet Coke?
Oh,
Don't
I'm
worry.
so
No
sorry.
problem.
Because they don't have it at Caribou. Like they
No,
asked
they
me if
don't.
they had
Don't
coffee.
worry, sorry. I didn't
And I'm like,
realise
I'll
that.
pick that up.
No problem at all. I'll just drink my boring water. That's fine. Ah, okay. Let's hope that it's it.
Well, I did have to sit. Oh, yeah, that's true. Yeah,
No,
yeah.
she said she didn't want to do a witness part of her. So.
Yeah, totally.
might just be that both of them are picking up the same sound.
Yeah, I honestly don't think it's anything to do with ours because yours are amplifying and ours are not amplifying.
Yeah.
They're only recording.
Yeah.
So I don't know that
Yeah.
they would provide.
The only thing I can imagine is because that noise only comes when you've got two like
Yeah.
phones or phone next to a computer.
Yeah.
So what I want to try is we move the mic just to move it over here.
I can't move it over there because I have got to be
Yeah,
able
but
to
have
hear.
them sit on this side so
Oh,
that our
okay.
mics don't pick up the
Oh,
sound.
okay. If you can get him to sit
Yeah,
here,
that's what
all right.
I'd rather-
Yeah, okay,
Because
that's right.
yesterday the mics weren't on this side. I think the mics were on this side.
Yeah, because he was sitting there, so
Exactly.
he had to move it when
Which
he
is the
moved.
only reason I think it's picking up so much
Okay.
signal. So I'll make sure that nobody sits on this, they sit on that side. So
Yeah,
that you
I'll
can
move
pick
that
up.
over and then we'll move it over.
I approved everything. I do not provide the graphics.
Just to make see if
Yeah,
that
all
makes
right,
any
that's
difference.
fine. If he sits
Yeah,
there,
no,
then
we'll
I'm
get
happy,
them to-
so that's great.
Yeah, that's
Excellent.
the most important thing.
Okay.
Try that. We'll move this over here.
Yeah.
I'll tell them when they come in to make
Yeah.
sure this sits on this
Yeah.
side. Right.
Okay.
Thank you.
We're going to, we're going to put the witness on this side.
Ah, right.
We were just discussing it, do we just if there's a feedback
Yeah.
problem, so if we
Yeah.
move that's over there and then you
Yeah.
push the
All the
mics
other
over,
mics
it
should
should
move
be
to the
okay.
side. Yeah, like I said, the only reason I think it's doing that is because it's picking up
Something,
three
that's
signals.
it's a feedback.
So
sound,
two
so-
mics, and if we move it to one side, at least it'll be a bit further.
Yeah.
I mean, our mics will pick it up
It'd still be
from
okay
the
for you
other
to
mics
record.
anyway.
Okay, yeah.
So as long as you get the sound
Yeah,
into that mic,
so
that's the most
that's
important
fine.
thing.
Yeah, okay, great.
Yeah, he decided to change places today.
Yeah.
So as long as it's fixed.
Mm.
One time it was too big. The
Really?
other one
It was really
bad.
It's colder now, right, in the courtroom?
A little bit
thank
cooler.
God.
It has been very, I know Anne's been finding it really warm all week. It's been kind of hot.
Because the AC's been on 23 degrees.
Really? Yeah.
And it never is. I think it's just because nobody has used the courtroom for a
Oh,
month.
so they
because
should
we don't
have
have
made
the
it
upgrade.
cooler. Yeah.
So I'm guessing they just didn't really bother with
They
the
didn't think
AC.
about it, yeah.
And it's been pretty empty, but now that you've got so many people in one room.
Yeah, it just heats up pretty quickly.
to him. You definitely need more than 2 hours.
I can wish for a movie too. It just depends on what it is. It just means that we're wishing.
Yeah.
And it's just a bit pressurised, isn't it?
I don't know if he's got. I can actually check his agenda.
I mean, I'm inclined to leave it and then just see the place on. I mean, the other thing is, it's whether or not providing the reviews from the case. And we think that we would
He's
like
leaving tomorrow.
He's
leaving tomorrow. I don't know if he's got any. He's got nothing else planned for this evening. Like he doesn't have any plans to see anybody. No, he's not. He's leaving tomorrow morning. If there's a reason, I think people may ask you to explain your reasons for why you need more than 2
I
hours.
don't think we're doing this. I'm saying to you, I don't think we're doing it. I'm going to be rushed, but I'm going to try and keep this 2 hours. But then it's
Well,
really
I'll warn him that there is probably it might need to go over and just ask him how long he's willing to go over, just so everybody knows and he can let everyone know.
He's there for my stuff. Do you know what we do? I think we do.
But it might be worth asking, just because if you don't finish by 2, he will by 5, he'll just get up and leave. So just to warn him, at least it might happen. If it doesn't, great. If it does, at least he's got an idea that it will. You don't exactly, but just it may need to go on for an extra 15 minutes.
But then we've got research as well. And then we also want, I just want to put in the review. We say
Yeah.
so
I'll discuss it in the news after much, I don't think he's back yet.
yeah. I mean, I'm
Well, if you need 2 hours, then they're obviously going to need at least 10 minutes for the examination.
and we also want to put in a review as
Exactly.
well.
So just to let him know that you need 2 hours, but that means it might mean the hearing will still need to go on for another half hour to take it to his preliminary review and discuss. You guys still need to discuss when the next witness is going to give their evidence. Exactly. But
So there's quite a lot of things to get through in 2 hours.
exactly. Which
So
is
I'm
what I'm
concerned.
saying. You might finish in 2 hours, but finishing everything else might be too much. So
Yeah.
if it's a matter of he's leaving at 5, then it may be best to just discuss what's going to happen next, give a preliminary review, and everyone goes home,
Yeah.
and have the witness come with the others. I think there's 2 more.
Yeah, exactly. You see, yeah. That's
What is it? So I'll bring it up with him.
Yeah, no, I think that's better because, 2 hours for me, so I'll go something else. And that's what I'm concerned about, because that might mean that I'm rushing and rushing, and I don't want to rush and squeeze 2 hours into an hour just because we have a busy. So, okay. That's very sensible.
Why do you have so much chance to finish it together? I don't understand.
Why not happen?
It's so hard.
It's like everybody's.
Nobody's listening one time, ever.
I think you get mine.
In 1 hour since it was due. It's only me on over there. 20 minutes to get it to me, otherwise I'm not going to $200.
Cheers.
Yes. Yes. Yeah. So he suggested that you guys spend a couple of minutes just discussing how this afternoon is going to play out. So if you need 2 hours, and if you need to re-examine how many long.
I mean, I have no idea whether I'm going to re-examine, obviously, but I can't imagine there'll be much. I mean, to be honest, I'm surprised you've got 2 hours for this one, but it's all in your call. It's not that I'm going to say on the topic.
It appears he's changed his mind about the preliminary.
Sorry?
It seems that he's changed his mind about the
He
preliminary.
doesn't want to offer us.
I'm not, it seems like he doesn't.
Okay.
So he said take a couple of minutes just to think about it, and then if you want to say anything to him about.
Well, we've had a chat. I think it's really just a question of sort of.
Okay, well then you can bring. Yeah? Yeah? Yeah. Okay.
So that's what I'm saying.
But he's not keen to go.
Yeah. Fair point.
Yes.
My Lord, can I just perhaps take this opportunity to raise a couple of concerns that I've thought about over the lunch adjournment? I've said that I will take approximately 2 hours with Mr. Ramadan. Now, I am going to try and keep it short, but it may be that I do need the 2 hours, and of course then that doesn't factor in.
Well, I'm not letting you go part heard. We either start him or we don't start him.
Well, my Lord, in relation to starting him, of course there's then the matter of re-examination, There's then issues relating to where we might need to sit next and timetabling, and that will take some time as well. And then, of course, my Lord, you indicated about a preliminary view at this juncture. And so my concerns are that it may be that I'm forced to rush Mr. Nabil Ramadan under circumstances where I'm not content to do so. And so, my Lord, those are my concerns regarding the timing this afternoon.
Well, we started at 9:30 this morning. I don't think it's really viable to sit much after 5 o'clock.
I appreciate that, and I completely understand that, my Lord, which is why I raised these
The
issues
shorthand
now.
runners are slaving away over there. I'm slaving away. Well, I'm not slaving away, but I'm here.
Yes.
And the court staff have got to be on hand while the court's running.
I appreciate that, my Lord, and that's why I raised these issues today. So, or now, should I say, after the lunch adjournment. And so, my Lord,
What do you say about then? Well, let's hear what Mr. Thompson says about all this. Well, are you prepared to let Mr. Ramadan go part heard?
I think it would be highly undesirable because
Not
it could be
very
weeks or months.
Right.
I mean, my Lord, I'm entirely in Lordship's hands, and again, in my own friend's hands, because my re-examination is unlikely to take more than a couple of minutes. I mean, I had 4 questions for Mr. Mishra and 1 from Mr. Elderbooz. I don't imagine much to it. I have to say I'm a little surprised that my own friend has quite so much for this witness, but if she does, she does. I simply, I mean, I endorse with respect to everything your Lordship has said, which is that we shouldn't have too long a day, and it would be wrong for Mr. Ramadan to be part heard. But it's entirely with respect between my own friend and your Lordship.
and my Lord, it's on the basis that you said that you didn't want to sit past 5 o'clock that I've raised these concerns now. My Lord, we want...
I mean, if you're looking at seriously nearer 3 hours than 2 hours, there's no point in starting it. On the other hand, if you're looking at 2 hours with a very minor overrun, we can start it. But I'm talking about 5 minutes or something like that.
Yes, my Lord, and then there's the issue of timetabling as well for the next occasion.
Well, that won't take very many minutes.
And then, my Lord, we've discussed this issue about you proposing...
Well, I'm going to disappoint you about that, both of you, because if you'd intended that there should be that discussion, I'm afraid I'm not... I haven't got sufficiently into the defendant's evidence to give you anything worth having
Yes, my Lord.
at this stage.
Yes, my Lord, in which
At
case...
least you haven't got sufficiently in the defendant's evidence, I should say more accurately. Yes, go on.
My Lord,
So,
I think my cross-examination will take in the region of about 2 hours. Now, again, I don't want to be in a position whereby I'm rushed, and so it's a matter for you, my Lord. I've made my observations and my
well, you
concerns.
better start, and I'll reserve the position as to asking you at 5 to 5 how long you've got to go, and if you tell me a long time, then I'm just going to adjourn it. All right.
Mr. Ramadan.
Please state standing and state your name and your address for the court, please.
Nabil Ramadan, Worka 4, Dubai.
And if you could please place your hand on this and read out your oath card.
I swear by Almighty God that the evidence that I have about to give is the truth and the whole truth and nothing but the truth.
And when you answer your questions, please respond to the judge and speak clearly into the microphone. Thank you very much.
We have some microphones, but try and keep your voice quite loud and then everyone will hear you. Could you give the court your full name and address, please?
My name is Nabil Ramadan. I live in Worka 4, Dubai.
In front of you there is or should be put a bundle C2, and behind tab 10 there will be a document which in the middle of the page says witness statement of Nabil Ramadan. Do you see that?
Yes, I do.
And then if you go forward to the last page in that tab, there is a signature, page 396 in handwriting.
Yes.
Just, that's not the mic, that's the mic, I suggest you say.
So,
Both bikes are operative, so.
We need him to stay here for this, Mike, otherwise there will be the interference again. So just but we'll keep it there and put this like it'll pick it up, don't worry.
your question?
That signature on page 396, whose signature is that?
This is my signature.
And is there anything in this statement which is incorrect that you want to correct, or is it all true?
I just want to update, I'm no longer in the IFC authority. I am now the Group Chief Human Resource Officer of Junior Group.
Thank you. And apart from that, is everything in this statement true to the knowledge of your belief? Knowledge of belief?
Yes.
Thank you, Mr. Ramadan. There'll be some questions from Bloomberg.
Yeah.
Mr. Ramadan, you are a HR specialist, aren't you?
Yes.
And that's really your field of expertise, and you're very comfortable with HR matters.
Yes.
Yes? Can I ask you to turn to paragraph 11 of your witness statement, please? Can you have that there? So, you're appointed chairman of the HR committee in early 2007 until it's dissolved in June 2010, yes?
Yes.
And you recall, you say in paragraph 11, that you were provided with a volume of papers by the defendant shortly after your appointment, and you were tasked with reviewing the process and work done in establishing a compensation structure for senior management and assisting management in creating applicable human relations and remuneration policies and procedures. You see that there?
Yes.
In reviewing the process and in establishing a compensation structure for senior management, it's right to say, isn't it, that you would have had direct involvement as to how bonuses were going to be paid?
I don't understand your question.
Well, you say, paragraph 11, you're given a box of papers, and the HR committee is tasked with reviewing the process and work done in establishing a compensation structure for senior management. You see that there?
Yes, but these papers were related to, at that time, existing people who have been offered employment contract with DAE, and we were being asked to look at these files and
Right.
come up with observation.
Right. So your work, it says here, in establishing a compensation structure for senior management.
Yeah, that was the second part of it, to
Yeah.
put a framework for future standardizing the compensation structure for...
Yeah. So I'm suggesting to you that you put together the basis upon which a bonus was to be paid. You put together the structure for payment of bonuses.
You mean like we put together? It was proposed always. Our role is not executive role. We could provide it with a certain recommendation, and there were certain things done previously, and we were reviewing based on that and put the framework for going forward.
Well, it says it quite clearly there, establish a compensation structure for senior management. You were establishing a structure by which senior management was going to be paid a bonus, yes or no?
Yes.
Right. And in establishing that structure, the HR committee decided that senior management, namely C-level employees, would be entitled to a bonus.
Subject to performance-based. So
Right. Subject to performance-based.
it depends, because, and you had previously contract or employee who were in a given contract, which fixed contracts, and the bonus were, or certain performance criteria were already mentioned in the contract. So
Right. oversaw the appointment of the claimant, didn't you?
Yeah, we were in the process of selecting can I refer to Mustafa? Or?
Pardon?
We were in the process of, we were mandated to, by the MD to assist the CEO in identifying a senior person to
Yes.
lead the function.
And you approached the claimant, didn't you?
Yeah, it was him and a few others maybe.
Right. And you recommended the claimant for the role of HR person?
Yeah, he was interviewed by us and we recommended him.
Yes, you recommended him. And as the HR specialist, it's right, isn't it, that you would have been the person that would have considered the draft term sheet in relation to the claimant's appointment?
But that's an executive role, not my role.
Pardon?
That's an executive role, the DAE management role to draw the contract. We were in the process of agreeing high-level compensation and standard benefits as a normal practice. Our role is not an executive of doing executive roles by being operationally involved.
Yeah, so agreeing high-level compensation, and that's also the process as well. Well, you're nodding, as I understand that
No,
you...
what's the question?
Pardon?
What is the question?
Well, you were agreeing high-level compensation and also the process by which bonuses would be paid.
With this case, with Mustafa's appointment?
Yes.
No, what we agreed in terms of what sort of salary, and
Pardon?
salaries and standard benefits. So, and company's standard approach of performance-based, or if there is anything in the company at that time. Because at that time, nothing was established. When we took the role, there are certain things were previously done by the previous contracts and our role was to look forward how to fix these things.
Okay. Can I ask you to turn to D1 tab 15, please? This is the claimant's employment agreement. As somebody who oversaw the claimant's employment and his appointment, you would have been familiar with this contract and the terms therein.
I remember, as per my witness statement, I stated...
I can't hear you, sorry.
As per my witness statement, the former CEO, we discussed with him and the MD the standard benefits and compensation, and we were not seeing this, never been shared with us the contract before issuing.
Okay, you discussed with CEO.
And the MD.
Right, well, can I ask you to turn to page 33, please? Yes?
Okay.
Are you saying, is it your evidence, that as the HR specialist of the HR committee overseeing the claimant's appointment that you were not familiar with this clause at number 8?
I haven't seen this one at the point of appointment.
That's not the question. Are you saying, as the HR specialist and the chairman of the HR committee, somebody who oversaw the claimant's appointment, that you are not familiar with this clause at page 33, number 8?
Yeah, I'm not familiar. I haven't seen it before. Because
in any context whatsoever?
The previous contract were not standard, so all the previous executives who were hired, they had different standard or different entitlement. So there was no such standard in DA to follow when it comes to bonus or entitlement or benefits.
So isn't clause 8, that's a standard bonus entitlement clause, isn't it? You would find that clause in most C-level employee contracts.
As I said, like when part of my statement, when we reviewed the file of the senior executive before appointment of Mustafa, they were not all standardized. They had different benefits, different clauses, different customized approach for each individual.
And how would they differ then?
I don't know. I mean, I don't have the document in front of me, so I don't know. I don't remember. So I remember some of them had different flight allowance, some of them had different leave, some of them had.
Yeah, I'm not talking about, I'm just talking about this clause,
Yes.
clause 8.
I don't remember, so I don't.
So you're not familiar with this clause 8?
I'm just saying like, they were not all standardized. So
Pardon?
they were not standardized across sea level.
You're not, you're saying you're not familiar with clause 8? Is that what you're saying?
Yes.
So when it came to establishing a compensation structure for senior management, you didn't look at this clause 8 at all?
I'm confused a little bit. The process was, our role was to take the DAE human resource approach forward, so and fix what was done previously by the previous.
No, it wasn't just that, Mr. Rundle. I'm sorry. Paragraph 11, it was establishing a compensation structure. That's what you were doing.
Yeah.
Yes.
But it
And
was at the,
establishing is putting it in place.
yeah, it was at the same time as the hiring of Mustafa. So
Yes. Okay. And so my question to you is, are you suggesting to this court that in no way, shape or form, as the chairman of the HR committee, were you familiar with what is set out at clause 8 at page 33?
as I said, I mean the contract was not reviewed by us, or I mean we have not seen the contract before it was issued. So at that time of issuance, I didn't see this one.
And you've never ever seen this clause in any other context whatsoever?
I might see the other clauses of the previous contracts, but not in this one. The previous file that they provided to us.
You worked with the claimant quite a lot because he was, or rather, you were the chairman of the HR committee. So in that context, you worked quite closely with the claimant, didn't you?
I know Mustafa before that, so it's.
Pardon?
I know Mustafa before that time, so it's.
Yeah.
As a committee, we have been working all as a team. My role was a chairman, but it was all collectively
And
decision.
is there any reason, did you have any reason whatsoever throughout the time that you were working with him to doubt his honesty and his trustworthiness?
No.
No. And it's right, isn't it, that you always found him to be diligent and conscientious?
That a question?
You always found him
Yeah.
to be diligent and conscientious?
Yes.
And as the chair of the HR committee, you understood, didn't you, that C-level employees had a provision within their contracts that allowed them to be paid a bonus, but that was contingent upon MBOs being agreed. You
Yes.
understood that, didn't you?
Yes.
You also understood, didn't you, that those MBOs had to be agreed no later than 90 days from the commencement date of an employee.
Yes.
You also knew, didn't you, that for some employees, MBOs had not been agreed.
And we came to know about it. So.
You came to know about it. And you were told that out of 26 employees that had these bonus entitlement provisions in their contract, only 11 had agreed MBOs.
Something like this. I don't remember exactly, but something like this.
D1 tab 22. behind tab 22 is the performance management system. You knew, didn't you, that where individuals had no agreed MBOs, that the performance management system, this system would be used to evaluate and assess how much bonus should be paid?
Yeah.
And if we go to page 141, 142, 143, the process was an IPC at the start of the year that would define KPIs. Would you agree with that, yes?
Yeah.
And then a year-end performance appraisal where those KPIs would be assessed. And against that assessment, there would be then a rating. You're nodding your head, just for the
Yes,
transcript.
yes.
Can you say either
Yes,
yes or no?
yes.
Sorry. Is that a yes?
Yes.
Yes. And then against that rating, the company would pay a bonus.
Subject to company's performance and if there is no contractual obligation.
Sorry, I don't understand.
It's subject
your
to company's overall performance if the company is willing to pay a bonus or no, and unless there is something specified in their contract. I'm just talking about DAE case because you had unique cases.
Right. But you've said subject to the company's performance. So you're talking about revenue when you say that.
Yes.
But that was only in relation to LTIP bonus, wasn't it? Not an annual bonus.
I think both. I mean, if the company is not performing, why would you pay bonus?
Well, did you know that there were two types of bonuses payable to C-level employees, an annual
Yeah.
and an LTIP bonus?
Yes.
And the annual bonus was paid by reference to how well the individual was doing, wasn't it?
Yeah, it's because they had all in their contractual obligation, I think, few of them.
How well, okay. It was the LTIP bonus that was dependent upon how well the company was doing and how long that particular employee had been with the company.
Yeah.
Yeah. The second thing you said was if the company was willing to pay a bonus. It wasn't a question of willing, was it? It was a question of what the individual was contractually entitled to.
Yeah, I said that, if subject to if there is any contractual obligation.
I'm sorry, I missed that. Can I ask you to turn to D1? Sorry, just sticking with this point. Can I ask you to turn to tab 15, D1, the agreement? Now, using your knowledge as a HR expert and as the chairman of the HR committee, this is clause 8 of the claimant's contract. Would you agree with me that subject to an agreed target, so conditional upon whether or not the claimant achieves a target, he is entitled to a bonus?
If the contract says that, that's
Well, what do you say?
whatever the contract says, so it's not whatever I feel, it's whatever is in the contract.
And I'm putting this contract in front of you, and somebody who's the head of the HR committee, if you were
I
If you were
think
looking at this-
I need to clarify something. Yes, I'm an HR expert, but I don't have an executive role in DAE. We used to meet 3 or 4 or 5 times a year. Not to get involved operationally, you had the CEO, you had the MD, who were responsible to run the day-to-day job. Our role was we were meeting a few times a year to agree on a certain strategic thing as per the term of reference. And it's not my role to do operational job. Because I'm not an employee of DAE.
Yes, but you as somebody, as the chair of HR committee, you were making decisions, were you not?
Yeah, based on the data we're given to us.
As to individuals' entitlement.
Yeah, based on the data provided to us.
So, if this data had been provided to you, clause 8, would you have said that the claimant was entitled to bonus or not?
It says the company may pay the executive the annual bonus as follows. So
Yeah.
these criteria are met, I think the company may pay. As
If
it
the
says.
criteria is met.
May, it says may, so it may,
Right.
it may not.
Can I ask you to turn up D139, please? This is a document titled DAE Organisational and Leadership Team Performance Evaluation for 2007. Yeah? The
You need to
claimant
confirm.
says that the previous CEO drafted this document.
Sorry?
The claimant,
Yeah.
his evidence is that Bob Johnson produced this document. Did this document ever come before you?
I don't remember. It may come to the committee. I don't recall that. I don't remember now.
Page 261. This is a table showing projected payments of LTIP. Yeah?
Yeah.
On the right-hand side is a column titled LTI profitability. Do you see that?
Yes.
In certain rows it says not defined, not defined, not defined. That reference to not defined is in relation to parameters within the contract of employment by which bonuses would be paid.
Okay.
Yeah? And that is sorry, just keeping that open. Can I ask you to open D2? D64. And if we go to page 342, this was a table that you were presented with. Do you remember that?
No, but the paper says that, didn't it?
Well, start of the document is at page 341.
Yeah, it's 5 years ago, so I don't. It says I have received it, so I have
Yeah.
received it.
And what the table at 342 shows, all those people that had agreed MBOs, it's the fourth column across. You see that?
Okay.
Yeah? It also shows target bonus percentage, which is the 50 or 100 for the top one, and maximum bonus percentage, which is 120. You see that?
Yes.
So, in terms of the parameters of a target bonus or a maximum bonus, where you do have a percentage stated, would you say that that's defined or not defined?
If it says here 100%, so it's whatever it says in the paper.
So, in the claimant's employment agreement, and I know you say you haven't seen it, it was the parameters for target bonus and maximum bonus were defined. So would you say as a HR specialist that that would give some certainty as to the amount of bonus that had to be paid to the claimant?
Whatever the paper says, I'll take that one. So it's, I'm not here to assume something. Whatever it says in the paper, it's been reflected, I assume.
Can I ask you to go back to D264, please? Sorry, 63. There's an email attaching this document, which was sent to you on the 2nd of April. It's the email at page 4,
Yes.
page 340. This is a document sent to you by the claimant. Yeah?
Do I need to confirm that?
Pardon?
Yes.
Do you recall seeing this document?
Yes.
Paragraph 6 states, the NRC are confident that their recommendations are credible from a contractual perspective. Now, you sent this particular email to the board.
No, to the MD.
Pardon?
I sent it to the managing director.
To the managing director. And it was signed off by the NRC.
Yeah.
So when it's stated there, NRC are confident that their recommendations are credible from a contractual perspective, what did you mean?
Is there contractually we need to pay them bonus?
Why?
Bonus. Sorry?
Why?
It's aligned with that. I mean, just based on the documentation and presentation was provided to the committee.
Yeah. But why do you say from a contractual perspective you need to pay it? Explain to me the basis upon which you would say that, please.
So we need to look at each contract if it says that or if it says that, that's why we say based on contractual obligation.
Sorry, I can't hear you.
It is based on the contractual obligation, so why would I say that? Because we were informed by the DAE management that this is part of the contractual obligation.
And you didn't do anything yourself about checking that?
We trust the head of HR, so he was part of it. He was the secretary of the committee, so we took his data as a proof of evidence.
You said earlier in response to a question that I asked that the bonus payment was contingent upon MBOs being agreed no later than 90 days. As a HR specialist, would you agree with me that if there is a failure to agree MBOs, then that shouldn't deprive an eligible employee to a bonus?
As a general statement, yes, but I don't know the detail of each case is how does it work. There may be something internally.
On the 22nd, or around about the 22nd of June 2008, As the chairman of the HR committee, you were sent a consolidated dossier, wasn't it?
What, sorry?
On or about the 22nd of June 2008, you were sent a consolidated dossier.
I don't understand. I mean,
You were sent a package containing HR information related to bonus payments.
where? I mean, in the document, can you show
Can
me?
you not remember? You don't remember. So you don't remember around about June 2008 being sent a package, I'm going to call it package, with goals set out for each unit.
It may have, I don't know, if you have something, show, I mean, if you have some record.
Why don't you cast your memory back, and if you don't remember, then I'll help you.
I think I don't remember. It's been 5 or 6 years, so it's, or maybe 7 years. I don't remember.
So you're saying you don't remember?
No,
Okay.
but if anything in the email is there, that means that is.
Can I ask you to turn to tab 85 in D2, please? This is an email from Bob Johnson to Mark Fosterman, and it's titled Information for Your HR Committee Package. It says, the original MBOs by function of business and for me that were sent to NRC and Dr. Omar were fairly specific and measurable. That's suggesting that some sort of HR committee package was sent to the NRC and Dr. Omar. Now do you remember whether or not such a package was sent to you?
No.
You don't remember. Can you turn to D2, tab 89, please? This is a meeting that took place on the 1st of July 2008. Yeah?
Yeah.
Page 474. Within that meeting, the claimant tells you that employees have submitted their KPIs. Bob has approved them all, but he doesn't accept those KPIs. Yeah?
Yes.
Can you remember the background to this at all?
I think Mustafa said in one of the meetings, like he was not approving the quality of these KPIs. Or
Pardon?
MBOs. Mustafa has indicated like he's not approving the quality of these MBOs or KPIs.
Yeah, which had been previously approved by Bob.
Yeah.
Yeah. And that included his own IPC as well, of KPI or MBO, didn't it?
Who's he? Bob?
No. Claimant, it included his own.
I don't know. He's spoken generally, not without names, so I don't know.
Yeah, but his own, do you recall his own IPC being part of the ones that he said Bob had approved?
I don't remember. So.
You don't remember? If he had said that, then where he says that he doesn't accept those KPIs, it's plausible, isn't it, that he could be speaking about his own KPI as well?
And that's a general statement, so it's,
So yes or no?
you mean, does he mean himself, one of those people?
Yeah, he could mean himself, couldn't he?
Logically, not.
Why not?
He's an HR expert, so.
So he's saying he doesn't... Well, what he's not telling you about his HR specialist, is he's telling you that Bob's approved KPIs, but he doesn't accept those.
He as in Mustafa, right?
Yes.
So he will not accept his own? No. It's your conclusion, I don't know about.
4, please. Now, in relation to the KPIs that Bob had approved, that the claimant was concerned about, it was concluded, wasn't it, in this meeting of the 25th of August, that there would be a session to validate those existing KPIs.
To the question? Are you reading the minutes, right?
Pardon?
As per the
I'm
minutes?
asking you that it had been decided, hadn't it, that in the meeting of the 25th of August there would be a session to validate those KPIs that the claimant had a concern about.
Yeah, but I don't remember, I don't think this session has taken place. That's why there's no, I didn't see any record about it. So I don't remember if the session took place or
So you don't know whether or not the validation session took place?
But I don't think it took place.
And did you not think it your responsibility to check whether or not a session had taken place?
I think the CEO has to initiate that. So.
What did you see as being your role as the chair of the HR committee?
It says in the charter, so I don't, it's the detail.
No, what did you see your role? I mean, you were carrying out
Yeah.
this position of being the chair of the HR committee. What did you think your role was?
It says in the term of reference we are supposed, as a team, as I said, as a chairman, it's to take put the strategic element of human resource or DAE to establish it and approve performance management system based on the management proposal.
Sorry.
I don't have the term of reference in front of
No,
me,
to
but
establish and approve a performance management system based on the management proposal.
I think the policy and procedure, this was part of it to ensure.
Yeah, but you were carrying this role out. You had this position of chair of the HR committee. You're not saying to me that every time you had a meeting, every time you had to make a decision, you went to the terms of reference.
I don't remember now, but it was agreed a meeting should take place, but
Right.
somehow
So
didn't take place. So it's,
what did you see your role as being in your capacity of HR committee chairman?
to call for the meeting, we had a secretary of the committee, so I'm not sure if the meeting was called or not.
No, I'm not talking about the meeting.
Yeah.
Generally, you are
Yeah.
the chair of the HR committee.
Yes. We were involved
What did you see your role as being?
to look at the strategic element or strategic direction of the human resource and DAE, put succession planning in place, ensuring transparency in terms of process and alignment.
And what about in relation to these bonus payments? What did you see your role as being there?
We look at the proposal of the management and based on that we make a decision based on the proposal that they give. We make a recommendation to the managing director for his final decision.
And by reference to your earlier response, to see whether or not the management system, performance management system had been adhered to. Was that your role as well?
Yeah, but you have the CEO and the HR are your two people in the organization who to ensure this thing is happening.
Can I ask you to turn to tab 99D2, please? This is a meeting, or minutes of a meeting that was held on the 10th of November 2008. Page 505. And you're provided an update on the 2008 bonus. And again, the claimant tells you, doesn't he, not all the employees have signed their MBOs for the second year. Yeah?
Yeah.
And so where there is an absence of signing MBOs, you expect the performance management system to be used to evaluate bonuses.
Yes.
somebody to turn up D3, please? Tab 111. This is an email that the claimant writes to Mr. Mushahwa, who was the acting CEO at the time. By this time, you've been with the organisation in your capacity as chair of HR committee for about 2 years now, haven't you?
Yes.
And the claimant has written the email at 543 to George, which is then forwarded on to you. Yeah?
Yes.
Page 544. It goes on to talk about contractual provisions and bonus eligibility from a contractual perspective. And you've already said that you understood contractual perspective to mean whether or not an employee was entitled to a bonus. And as somebody who has established the compensation structure, you would understand that there are 2 categories of employees, aren't they? 1, discretionary bonus eligible, and 2, contractually bonus eligible.
Yes. And you had also previous cases, the contract were over 3 or 4 years, so they were running in the same time.
Okay. And the second paragraph there, I mean, this email was forwarded on to you, so clearly you must have read this email.
Yes.
The second paragraph there, bonus payments for the second category are contingent of the achievement of pre-negotiated MBOs. And you've accepted that a bonus was contingent upon MBOs being agreed no later than 90 days. So you understood that's what it meant.
Yes.
However, HR records shows only these people and Al-Hendi to have some form of approved annual performance target of year 2008. Bearing in mind you know that some employees don't have agreed MBOs. You understood that to read, didn't you? That the claimant was such an individual who didn't have agreed MBOs, but yet had KPIs.
I don't know about that.
And bearing in mind the information that you had and what you knew, when this email was forwarded on to you, you didn't have or you didn't spell out any concerns, did you?
Well, it was an agenda for the NRC meeting or the HR committee meeting.
And you had no concerns about what the claimant was saying in this email, did you?
It came from the DA, so from their management. So for me, it was forwarded to me. But as my practice, I don't discuss on a one-on-one. It's an agenda for the committee. So it was based on my practice. Anything was coming from the CEO, it will be tabled for the NRC meeting or HR committee meeting.
Yes, but you've told us that as chair of HR committee, it was your role to approve bonus payments
Me
and
as
make
chairman?
recommendations.
No, I don't approve. We recommend and it goes to the. I don't approve alone. There is other 2 gentlemen with me, and whatever we say, our recommendation goes to the managing director.
Yeah. And so, on that basis, if there was anything, and you've read this email, you've said that, you read it, if there was anything of concern, as somebody who's recommending bonus payments to the board, you would have raised your concerns, wouldn't you?
I think the email says clearly, please discuss, so it's not asking for my approval or anything. For me, my practice, as I said again, anything comes from the acting CEO at that time, I always take it to the committee, so that means been tabled to the following HR committee.
Are you seriously suggesting that if there was something of concern here that you wouldn't raise it with anyone? Is
I would raise with the committee members.
Right. And you didn't raise anything about the
I would-
contents of this email, did you?
Maybe I think as my practice, this may be already been forwarded to them as well.
Right. Can I take to D3113, please? It's an email at the middle of the page from the claimant to Mr. Shabwal. And that email again was forwarded on to you.
Yeah, same
Yeah.
thing.
Same thing what?
Table to the next HR committee
Pardon?
meeting. Table for the next HR committee meeting.
Well, it's not table, it's not an agenda. You
Yeah.
say that that's an agenda?
Are you on 551?
Yes.
551? Page 551 at the bottom? Yes.
I don't discuss, when it comes with this, I don't think I've discussed this with George. However, George is aware whenever such thing comes, it goes to the committee as a main agenda.
Right.
Because this is a annual performance related
Mr.
payment.
Ramadan, let me just backtrack, because I don't think I've asked you a question about this email yet. So thanks for that. Page 551, email at the middle of the page, in the middle of the page, that's been forwarded on to you. Yes? And Mr. Mashangwai is saying to you that, well, he's asking you please discuss. It's more than likely that you would have read this email, isn't it?
Yes.
Sorry?
Yes, I did.
Yes,
read it.
you did read it.
Yes.
Second paragraph, kindly note that this spreadsheet also indicates the performance ratings for various employees. As you can see, your direct reports ratings are not available, therefore kindly finalise the process for the annual evaluation of your direct reports so as to provide the same to the HR committee. Do you see that there?
Yeah.
And what the claimant, did you understand that the claimant was asking Mr. Mushahwa to finalise the process by reference to the performance management system?
Yes.
And he was asking the acting CEO for a rating.
Yes.
Tab 115, page 557. It's a chain of emails, and at the top, Mr. Mushawa sends you the chain and says, let's discuss, please. Do you see that?
Yes.
So you knew, didn't you, that at this time, the claimant had a rating of 3.9?
Yes.
And it was against that rating that a bonus payment would be evaluated and assessed.
Yes.
And you had no concerns with that?
No.
Because Mr. Mushahwa then sends you an email at tab 125.
You say you had no concerns about that rating. Did the rating in any way surprise you, knowing the claimant, as you did?
Mustafa was I think he has contributed a lot to the organization, so I think as a committee we even regarded that in one of the meetings by saying he did a good job, so he put a lot of good things in place.
Page 583, tab 125. Mr. Mushahwa then sends you an email over page 584, and he tells you in 3 particular cases, and he's referring to the claimant as well, isn't he? You understand that?
Yeah.
I had numerous discussions with each individual and can confirm that my recommendations are based on an in-depth and factual evaluation. You had no reason, did you, to doubt what Mr. Mushahwa was telling you, namely that he had conducted an in-depth and factual evaluation?
Not at all.
Our earlier recommendations were based on payment to target level. However, upon further reflection, it transpired that there was a case for awarding a level payment, awarding a level between target and stretch target. Moreover, kindly note that these two employees, somebody and Mustafa, have not received any bonus payments since joining DAE, despite having now completed more than 2 years with the company. So you had no reason to doubt what you were being told by Mr. Mshahwa, did you?
No.
Because in fact, on the 5th of November 2009, page 585, tab 125,
Sorry, which page?
585,
Okay.
you were also told by Mr. Mshahwa that Mustafa had played a pivotal role in DAE. And that's right, isn't it? He had played a pivotal role in DAE.
Yes.
And his performance was such that in the previous year he had saved the defendants' organisation millions of dirhams.
Yeah, that's the CEO's.
And you had no reason to doubt what the CEO was telling you there.
No.
Can I ask you to turn to tab 117, please? This meeting on the 27th of May 2009, page 564. This is where the pot of 6 million has been decided, yeah? For the bonus.
Yes.
And the last paragraph there, NR is you, isn't it? Nabil Ramadan inquired on any bonus payment for other employees who are not contractually eligible to bonus payment. And it was then agreed that no bonus payment will be made to this category of employees, bearing, I think that should read, in mind that a number of salary adjustments were processed recently. Yeah?
Yes.
Those, who are you talking about when you said those individuals not contractually eligible to bonus payment?
It's a general statement.
Pardon?
It's a general statement.
Yeah?
Whoever is not contractually eligible, because I think it was during a difficult economic time, so nobody was paying bonus.
So those people that may have had a discretionary provision for bonus in their contract?
Yeah.
Somebody like Ms. Jones?
Who?
Ms. Jones, Leslie Jones?
I don't know about her contract. So.
And if I told you that she was paid a bonus, even though she had a discretionary provision in her contract, would you be surprised, given your instruction in the meeting of the 27th of May?
Yes.
You would be surprised. Why?
Because it was agreed that we'll be only paying bonus for those who are contractually eligible for it.
And for any payment on a discretionary basis, would you expect that to be approved by the HR committee?
I would expect to be highlighted to us and then it takes to the MD for a final decision.
And do you ever remember it being highlighted to you?
Not that I remember.
Do you ever remember taking it to the board of the MD for approval?
If I don't remember, how would I be taking it?
Page 566. These are minutes of a meeting on the 17th of August 2009. Second paragraph from the bottom of 566. Mr. Mshahwa tells the meeting that entitlement for LTIP is mainly for DAE Capital Team, with only 2 employees from DAE Holding being eligible. As somebody who oversaw the claimant's employment and somebody who looked at compensation structure, you understood, didn't you, that, and you knew in fact, that the individuals that were referred to DAE Holding being eligible were Mr. Tarapoor and the claimant.
I don't recall it was the names were discussed there because we go with the recommendation was given to us. So I don't remember if the name was discussed there. So
But through your knowledge of both the organisation, of overseeing the claimant's employment, of knowing that he was part of DAE Holding.
yeah, I mean these are the list of the senior people at C level in DAE Holding.
Yeah.
But it was not. I don't believe it was clearly mentioned in the minutes. The name.
No, it wasn't mentioned, but if it was said, 2 employees from DAE Holding, who would you have thought it was going to be?
C-level. So who, the C-level of the organization, and
Yes, who?
I think it was Mustafa there and the chief financial officer.
Feroz Tarapul.
Yeah, I don't remember if there was anybody else there. So.
Yeah. So when it was said in that meeting, 2 people from DAE Holding, you would have known it's Feroz and the claimant.
Somehow.
Before Mr. Mushahwa writes his email to you on the 5th of November, you have a meeting, don't you, on that very day? Tab 123, page 576. See that?
Where exactly?
Page 576.
Okay.
Yeah? In that meeting, the claimant tells you about the 6 million pot and that there were staff who had received more and some had received less.
Yes.
Yeah? And Mr. Mushahwa's, rather, the claimant gives you his feedback on Mr. Mushahwa's proposal as to how the 6 million pot should be distributed. Yeah?
Yes.
And you were aware, were you not, that this was the time when the claimant disagreed with the company's calculations in relation to his bonus?
So what was the question again?
It was around about this time that the claimant had told the company in relation to the calculation of the value of his bonus that he disagreed with it.
Where exactly it says that?
Do you remember it or not?
But are you referring to a minutes of meeting or?
I'm asking you, do you remember it or not?
No.
Page 577, at the top there, Mr. Juma states that the proposal recommended by George Mushahwa doesn't make sense and so the committee doesn't approve. Do you remember that now?
Yes.
And do you remember why it didn't make sense?
It says that, the below paragraph.
Yeah, but do you remember why it didn't make sense?
At that time, I mean, now I don't remember why. I mean, I have to go through the details. So.
Right, and if I suggest to you that the reason why it didn't make sense is because despite some individuals having the same rating, in percentage terms, those individuals were either getting more than what they were entitled to or less than what they were entitled to. Do you remember now?
I don't remember the details, I'm sorry.
Do you remember?
No.
No. Page 577, you're also told, aren't you, that the acting CEO was supposed to have a session with his direct reports and then give a rating. Yeah?
It says that, yes.
And you're informed, aren't you, that as far as the claimant was aware, Mr. Mushahwa hadn't sat down with individuals to rate their performance.
At that time, yes, it looks like.
You were told that. And you were also told that there were no MBOs.
We need to be careful here because you had a transition period of 2 CEOs, so
Right.
certain things were happening maybe before, and the acting CEO took over. So it's,
That wasn't the question. The question was, do you remember being told in this meeting that there were no MBOs?
I need to read the minutes. I don't remember on top of my head.
Okay. 6th paragraph down. Email, paragraph starting, MAH said, when saying that CEO doesn't have any authority, it's incorrect. The CEO of the company has a lot of authority. Contract says that there should be MBOs that should be reviewed by CEO and the employee. CEO should set the MBOs for his direct reports. There was no MBOs.
Okay.
Yeah?
Yes.
And again, having been told that there are no MBOs, and having told that the CEO, acting CEO, had given a rating, you were aware that that rating was by reference to the performance management system.
Yes.
Now, in that paragraph that I've referred you to, the claimant is saying that the CEO of the company has a lot of authority. You don't dispute that, do you?
No.
And he does have a lot of authority, doesn't he?
Yes.
Pardon?
Any CEO has authority, so it's.
You're also told that the claimant had followed up with GM, George Mushahwa, and Bob's Robert Janice, isn't it?
Okay.
And invited GM to a workshop. GM declined the meeting on the date of the workshop, and GM advised that he's not available to carry on with the meeting. MAH replied to GM's office that HR cannot formulate the MBOs without the CEO's presence, and advised to reschedule the meeting. MAH reports to the CEO of the company, and if the CEO decides to proceed without MBOs in that event, MAH would not be able to do anything on this as he reports to the CEO. Yeah?
Yes.
And that's correct, isn't it? It's not for HR to define MBOs, it's for the CEO to take the lead on that.
Yes.
This next paragraph, MAH briefed on the process that was advised by HR to the direct reports of the CEO. They were asked to complete the form and to write what they had achieved in the form and to send it to the CEO. MAH ensures that everyone received this completed form. As this was not received, MAH advised GM that the performance rating for his direct employees was not completed, and MAH requested GM to finalise the process of the annual performance by meeting his direct reports. GM just gave MAH the rating. So you were aware of that state of affairs as well, weren't you?
Yes.
And you raised no objection.
Sorry?
You raised no objection, no concern about what you were being told at that point, did you?
I don't think anybody in the committee raised anything. So.
Can I ask you to take up D1, please? Tab 26, please. See that document there at 153?
Yes.
You're copied into an email that the claimant writes to the CEO at that time. Yeah?
Yeah.
And the claimant is saying that he wants his benefit entitlement, the housing and the car entitlement, to be paid in cash. Yeah?
Yes.
And it talks about the annual allowance to be paid in arrears in 12 equal monthly instalments together with a monthly salary. Yeah?
Yeah.
And Mr. Johnson writes back with "I approve," and you're also copied into that email.
Okay.
Again, as of the 19th of November 2007 and thereafter, you have no concerns, do you, about the claimant being paid cash in lieu of his benefits?
No.
And you don't think there's anything untoward about that?
No.
So, my Lord, I'm just going to take a moment to turn the back onto it, really, because I've come to an end. My Lord, you'll be pleased to know that I have come to an end of my cross-examination. Thank you.
Thank you.
Thank you, Mr. Ramadan.
Well, I haven't got any questions for this witness unless you have any.
You have not?
I have not.
Oh, I see. Right. Well, it was often said that it's often a good idea not to re-examine at all. However long or short the cross-examination has been. I've no questions either. Oh, I've got one more. I've got one question, as I recall. If it was suggested to you that the claimant, that is Mustafa, had so conducted the advice which he gave to the CEO of the defendant company as to trick the CEO into providing him with a bonus, not in 1 year, but in 2 or 3 years, what would you have said?
Well, knowing Mustafa, he will not, I mean, I know Mustafa as a person. I don't think and I don't believe he will do that.
Any cross-examination or re-examination? Right. Well, thank you very much for coming to give evidence.
Thank you very much, Mr. Ramadan. You can leave for your help. My Lord, I think that's probably as far as we can go.
Yes.
I don't know to what extent we can now deal with any other pragmatic matters, or whether the matter's simply going to have to stand over.
Well, I'd like to have, as I said, was it yesterday, or the day before, given some indication which you could, if you chose, pass on to your respective clients. But really and truly, I haven't had enough time to get on top of the detail of your witnesses' evidence.
Yes.
I got on top of the detail of the claimant's evidence, and it's your witnesses' evidence, which has been taken quite quickly, and there's an awful lot of it. And at the moment, anything that I said would really be so speculative, it wouldn't be worth your having it.
Well, I understand.
So I just don't think it would be much use to you at all.
Well,
The more concerning matter is where we go in terms of completing the trial.
yes.
Now, I have already indicated to you at our meeting that it will only be next week that I know what my availability will be over the next month or so. There are various possibilities. I am currently due to sit here for the week beginning the 23rd of February, but there is a prospect that one of two trials may settle during that week. Sorry? I'm reminded that we're only sitting on the 24th, from the 24th onwards, but at the moment, is that because Sunday's a public holiday? It's just decided it would run like that, yeah. Well, there would be, perhaps, during that week, a spare day to complete the evidence, and it may be more than a spare day if one of the two trials settled. I think the current estimate for the two trials is 3 days? 4 days. It's 4 days. So one of them's got to go to vacate 2 days. And the importance about that is that less my availability than the availability of the court, which has other trials going on at different dates. And therefore, the opportunity for me to sit has to take into account those other fixtures. Now, as I say, it may not be possible for me to make that trip for medical reasons. So I'm just in the position where I can't confirm to you that any time would be available during that period. It might be, or it might not be. I just don't know at the moment. The next possibility is at the very end of April, and sorry, the very end of March and the very beginning of April. I think the last day or two in March, and there is during that period 2 or is it 1 fixture? There are 2 fixtures. Sorry? Oh, I see. Right. Well, apparently the claimant's law firm is involved in both the other fixtures, so they may have some idea as to the viability of those fixtures. I haven't. But they fill up the available period then, and unless one of them settles, there wouldn't be any time then either. So there we are. We'll have to see what the prospects are, what the availability is. Experience suggests that time emerges, but very often one doesn't get a great deal of notice about it. So bearing in mind the fact that there are 3 more witnesses, or is it 4? 3 more witnesses to be called. We have to be satisfied that all 3 of them are available at the additional time, and that's really down to your solicitors to work that one out. And of course, counsel have to be available as well.
Well, my Lord, I was going to say that considerably lower down the list of priorities than your Lordship's.
They're too modest, Mr. Thompson.
Well, my Lord, I don't want to be the cause of any particular difficulties, but the 2 dates that you mentioned to me do ring alarming bells in my head for my availability. I wondered, I mean, obviously, I hear what your Lordship says about the contingency of the availability in any event, but and I'm not familiar with the way in which the court calls upon your Lordship's time, but I wondered if there was any prospect at all of additional time for your Lordship and space in the court building being made available in the next few weeks. I'm, as much as your Lordship and anyone else in the room, I suspect, keen to continue as soon as we possibly can.
Absolutely.
But of course it must be, with respect, I would say, scheduled for both councils' convenience as well as your Lordship's and the court's availability, because it would be, I think, impossible to continue in the absence of any of those persons or space. My Lord, I dare say the witnesses could be relatively accommodating. I think they all live in the jurisdiction, certainly in the country, and so their availability may be the least difficult to accommodate.
Yes.
But given the uncertainties in the situation altogether, I wonder if we can't do much more now than say we ought to liaise with your Lordship's clerk.
I don't think we can get down to serious planning till halfway through next week.
My Lord, yes.
We'll know much more clearly where I stand halfway through next week.
Yes.
And we can then go from there and work out very carefully what available dates.
But one other point occurs to me, which is that if we are going to have, as evidently we are, going to have another day at least for evidence involving at least the persons presently in court back in this room, it might be sensible to allow a little more time in order that your Lordship could have some oral closing at that point. Council should be able to deal at least with the major witnesses and some of the issues. I mean, obviously, if we had finished the evidence today, I could anticipate your Lordship saying, well, we'll have written closing submissions. But this is a case in my submission, given the nature of the claims, if nothing else, where it may be more appropriate to have oral submissions in addition to or instead of written submissions. Certainly, my preference would be, for what it's worth, that your Lordship heard from us orally in submissions. We would be able to take account interactively with your Lordship with the issues that were going to be particularly troublesome. I always find, for what it's worth, the difficulty with written submissions is that however much I try, I'm never particularly good at predicting which issues that the court is going to find my assistance would be more valuable.
Well, one way of dealing with it, and it's commonly used where the hearing lasts more than a week, is for there to be written submissions and maybe then a day set aside for highlighting.
Yes, well, my Lord, I absolutely...
And that can be done in this sort of case by VC, by video conferencing.
Yes, my Lord, what I was thinking is we might turn a problem into a solution, because if we are going to have a day face-to-face with the last three witnesses, subject to your Lordship's availability, it might be possible to schedule oral submissions the next day, or maybe with a gap of half a day or something at that point.
Well, I will expect to have written submissions at some stage.
Yes.
Whether there should be oral submissions as well as written submissions, I'll be, open to persuasion.
Yeah.
But what I would say is that it might be worth considering whether video conferencing couldn't be used for the three other witnesses. You can see the virtue of that, because it avoids a flying operation.
I understand that, my Lord. I mean, there are some, in my personal preference, it is to avoid it except where it's absolutely necessary.
I couldn't
for
agree
obvious
more.
Reasons.
I couldn't agree more.
Particularly where there might be some intricate cross-examination on documents. But I mean, the possibility...
And also another thing is, it's impossible to see the witness's reaction with any sort of accuracy at all by video conferencing. It's all right for an expert witness, but it's just jolly difficult for a factual witness.
Well, quite so, my Lord, and there's a lot that's lost in electronic transmission between counsel, the court, and the witness one way or another. So, although it is obviously a possibility, it's one that I would respectfully suggest to be left to...
It's very much a last resort.
Last resort, yes.
Yeah. Okay, well look, let's proceed on the basis that we'll revisit this, or parties will revisit this with the court, and the court with me, next week,
very well,
and finalise arrangements before the end of next week. All right?
Very good, yes.
I think that's the best thing to do. Otherwise, we shall get into really quite serious time lag problems.
Yes,
And that's very undesirable in this sort of case,
absolutely.
particularly when having regard to the fact that there are very serious allegations
Yes.
made against the claimant, whose, of course, reputation is at stake.
Well, absolutely, my lord.
So we'll go forward on that basis. I would just simply like to thank Council for their support and presentations in the hearing so far, and say that I'm sure that any future hearings will continue in the same vein.
Very good.
Right.
All right.
Right. If I leave this here, will it answer all the charges? Is that okay? Yeah.